All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated.
Good morning and welcome everyone in and outside the courtroom. Madam Court Officer, can you please call the case?
Good afternoon, Your Honor. This is case KSC BC 2020-06, the Specialist Prosecutor versus Hashim Thaci, Kadri Veseli, Recep Selimi, and Jakub Krasnici.
Thank you, Madam Court Officer. And now I will kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office. Mr. Prosecutor.
Good afternoon, Your Honor. Good afternoon to all. Appearing on behalf of the Specialist Prosecutor's Office today are Matt Halling, Earl Sullivan, Clemence Vol-Marvaldi, and I am Alan Teeger.
Thank you, Mr. Prosecutor. Now I turn to the defense. Mr. Kehoe, please.
Good afternoon, Your Honor. Gregory Kehoe, Sophie Menegan, and Bonnie Johnson on behalf of President Hashim Thaci.
Thank you, Mr. Kehoe. Mr. Emerson, please.
Good afternoon, Your Honor, and those inside and outside the courtroom. My name is Ben Emerson. I'm representing Mr. Vasili today, together with Mr. Andrew Strong and Ms. Annie O'Reilly in the courtroom as co-counsel, Mr. Samir Sally and Mr. Haradin Kuchi in the courtroom as legal associates, and Ms. Tess Hughes and Ms. Gabrielle Cohen as legal assistants.
Thank you, Mr. Emerson. Now I turn to Mr. Young, please.
Good afternoon, Your Honour. Today I'm assisted by Dr. Rudina Yassini, co-counsel, and Mr. Eric Tully, co-counsel, also by Ms. Riva Gachai. Thank you.
Thank you, Mr. Young. And finally, Mr. Ellis, please. Microphone, please.
I apologise. Good afternoon, Your Honour. Mr. Krasnici, represented by my co-counsel Victor Baiju, our support team member Fauzia Mohammed Taib, by video link Mentor Bachiri, and I'm Aidan Ellis.
Thank you, Mr. Ellis. For the record, I note that Mr. Thaci, Mr. Veseli, Mr. Selimi, and Mr. Krasniqi are not physically present in the courtroom, but attend this hearing via video conference. Now I turn to the Counsel for Victims. Mr. Laws, please.
Good afternoon to Your Honour and to everyone. I'm Simon Laws, representing the victims in this case, together with my co-counsel, Maria Radziowska.
Thank you, Mr. Laws. And for the registry, Mr. Nielsen, please.
Good afternoon, Your Honor, and good afternoon, colleagues. Jonas Nilsson, Judicial Services Division. I'm also assisted by many, but they're all outside the courtroom.
Thank you, Mr. Nielsen. 1 second, please. Thank you. And for the record, I just had a quick discussion with the court officer because apparently there are some minor problems with the internet feed. So please let me know if there is any problem with your connection, and I will break the time for the connection to be settled. But for the moment, I am told that it is very minor and it doesn't impact the audio transmission of the hearing. So we will continue unless you indicate to me that the connection doesn't work anymore. On 30 August 2022, I scheduled this 14th status conference. And as usual, I ask the parties to provide written submissions if they so wished. On 5 September, the SPO and 3 defense teams submitted their written observations. The purpose of our hearing today is to review the status of the case and to discuss the topics in our agenda, and specifically disclosure, the SPO's updated witness list, defense investigations and next steps, and victims' counsel submissions, if any. I will invite the parties to present their views in a concise fashion about each item. Let us now move to the first topic, which is disclosure. At the outset, I note that the SPO indicated that the expert reports disclosed for experts on the witness list are final, to the extent that no further information is sought from these experts at present. The SPO also indicated that it is mindful that it must seize the pretrial judge should it seek to call any additional experts. I also recall that at the status conference held on 15 December 2021, I took notice of the defense Rule 149-2 notices. I indicated that this would be included in my handover document to the trial panel, so the trial panel can take these matters into consideration when determining the witness expert status or the admissibility of the expert witness reports pursuant to Rule 149.4 of the rules. Therefore, I consider that we do not need to discuss this issue any further during our hearing today. I will also, as usual, give the floor to the parties on the disclosure of each category of evidentiary material separately. First, the Rule 103 material, which was not in our agenda, but I would like to hear the SPO on a recent disclosure package, which is Disclosure Package 418, comprising exculpatory material. Second, the Rule 102.3 material, which is material relevant to the case as listed by the SPO. And third, Rule 107 material, which is protected material for which the consent of the provider is required. So let us start with exculpatory material. At the last status conference, the SPO indicated that it had complied with its disclosure obligation regarding exculpatory material, and that it had reviewed and disclosed all of its Rule 103 material through 16 June 2022. On 26 August 2022, I rejected a defense request for a finding of non-compliance with the SPO's disclosure obligations. However, I ordered the SPO to file a comprehensive disclosure report by no later than Friday, 7 October 2022. First, to indicate whether it still encounters substantive difficulties in carrying out the disclosure of exculpatory material, and second, to provide a detailed explanation of how it conducts the review of documents in its possession for identifying Rule 103 material, how it determines which documents should be disclosed pursuant to Rule 103 of the rules, and how it plans and executes the release of disclosure packages. Since I issued the decision, the SPO released Disclosure Package 418, which contains many new disclosures that, according to the Krasniqi defense, are obviously exculpatory. The Krasniqi defense also indicates that the late disclosure of hundreds of exculpatory documents is yet further evidence that the SPO has not been fully diligent in its disclosure obligations, and that defense investigations and preparations for the pretrial brief are prejudiced by this delay. So I will first ask the SPO to explain the reasons for this late disclosure. Mr. Prosecutor.
Good afternoon, Your Honor. Thank you. I'll address this point. As Your Honor mentioned, the SPO has disclosed one further package of Rule 103 material since the last status conference. The overwhelming majority of these items, I think it's over 280 of the 304 if you include translations, were items that were reassessed as being Rule 103 in the course of the Rule 102.3 review being conducted in anticipation of Your Honor's 30 September deadline. There were also some items that were found to have been inadvertently missed following SPO verification checks. This was only 6 of the items in the package. One had 2 parts. As to Your Honor's reference to the Krasniqi defense's submission about obviously exculpatory content, the defense cannot substantiate any prejudice to its preparations. And just to take an example, the first one in the footnote where the Krasniqi defense says that in their written submission. It was an item from 2018, said to be obviously exculpatory. This was one of the reassessed items in the course of the Rule 1023 review. And the reassessment was made because it's a statement of a witness, and at paragraph 22 of this statement, the witness says he was treated well in detention. And that's what caused the Rule 103 determination to change. If you read the full statement, this witness also says he was kidnapped by the KLA. He was held in detention for a week. He had a hood over his head and his hands tied for all moments of his detention, except for when he was eating and drinking. And he was told after his release that he was suspected of being a KLA spy because he was the only person with his occupation that they released. And this is from a combined reading of paragraphs 6, 14, and 19 of the cited statement the Krasniqi defense mentioned. Even the statement in paragraph 22 that I mentioned, the exact words are meaningful. It says, he was treated well, not beaten or tortured. This was the item that was reassessed and called obviously exculpatory. All too often, the impact of Rule 103 disclosures is argued by the defense on the basis of timing alone. When did the SPO get this and when it was disclosed? But the actual Rule 103 content, or how difficult it is to actually process the content at the time it's disclosed, gets lost in a formalistic analysis of that kind. And it's critical towards evaluating the SPO's Rule 103 assessment method, or what prejudice, if any, is caused to the defense. The defense has these documents in the package under Rule 103. They can use them however they wish. If they want to use the document that I mentioned, because it's obviously exculpatory, we will certainly respond whenever they attempt to do that during trial. But in our submission, no further action is required in relation to this disclosure. We are mindful of Your Honor's direction to prepare the report that you mentioned, and we will do so by October 7th.
Thank you, Mr. Prosecutor. Mr. Kihu, please, on this topic.
You know, Your Honor, with all due respect, the attitude of the SPO when it has come to Rule 103 continues to be, excuse me, quite alarming. After all of Your Honor's admonitions as to the identification diligently and expeditiously, we've just heard an attitudinal speech by the SPO concerning their disclosures. Now, I know the Krasniqi team has some additional comments to be made about this, but this disclosure was made on the 31st of August, Judge. It related to Special Investigating Task Force interviews from 2013, 2014, 2015. SPO transcripts, not the Special Investigative Task Force, SPO transcripts from 2018, 2019, March and April, and May and September, October, and January of 2020, as well as newspaper articles going back to 1999. Why do we continue to, it seems, wrestle with the SPO for them to comply with Your Honor's orders? Is not when you get around to it. Immediately is not an attitude to come into this court as if they've been complying with Your Honor's orders diligently over the past several years. I submit to Your Honor, based on your orders, that they have not. Now, I'll turn the floor over to my colleagues, but the attitude that they have here is alarming, and there is yet no answer why these late disclosures to continue to come. And we certainly don't know how many are coming on the horizon. Now, we have a lot of other items that are going to be disclosed 30 days before trial, and we'll talk about those down the line based on the SPO's submission yesterday. But nevertheless, the question why this is happening remains outstanding and unanswered, notwithstanding somewhat of an aggressive response to Your Honor's interrogatory at the outset.
Thank you, Mr. Kihu. Mr. Emerson or Ms. O'Reilly?
Your Honour, Ms. O'Reilly will deal with all the disclosure issues at this stage.
Thank you, Mr. Emerson. Ms. O'Reilly, please.
Thank you, Your Honour. I just want to point out that this issue actually came up, this issue of whether there was 103 material on the 1023 list, last September, so 1 year ago. And at that status conference, Mr. Emerson and counsel for the prosecution got into a discussion, a back and forth, about whether or not there could still be 103 material on the 1023 list, and whether indeed the 1023 list, the items on it, had been reviewed by a human eye. And we were assured that they had indeed been reviewed by a human eye for the purposes of materiality, but that there was still a subset of data that had not been fully reviewed for exculpatory material, and that's at page 583. Now, I would just like to recall that 103 material is supposed to be disclosed immediately. Last September, the accused had been in detention for almost a year, and they were still telling us that they had to review some of those materials for 103, but that material will be handed over soon. We're now 1 year later, and we've just had 280 documents from that list disclosed to us under 103. So, Your Honour, it's our submission that they absolutely have not complied with their 103 disclosure obligations, and that there's a clear pattern of them failing to do so. Thank you.
Thank you, Mr. O'Reilly. Mr. Young, please.
Your Honour, very briefly, it's apparent from what the prosecutor has said respectfully that he appears to be relying upon the complexity of the task in hand in categorising exculpatory evidence. Frankly, Your Honour, we submit that's no excuse at all. The complexity of the process is no excuse for late disclosure. And if I recall correctly, Your Honour's words when introducing this topic this afternoon, Your Honour mentioned that we're coming on to deal with late disclosure in relation to this package. Given that that was Your Honour's word to describe the timing of the disclosure, may I invite Your Honour to consider making a finding of a violation of 103. Thank you.
Thank you, Mr. Young. Mr. Ellis, please.
Your Honour, what I detect in the prosecution's response a moment ago was a conflation of two, what we say are distinct issues, the question of timing and the question of prejudice. What Rule 103 requires in our submission is very simple. It requires immediate disclosure of exculpatory material. It requires that disclosure as soon as it's in the possession of the prosecutor. The question of prejudice may come into the equation later when Your Honour is considering what remedy may be available. But as to the obligation on the prosecution in terms of disclosure, it's very clear. It's an obligation to disclose immediately, as soon as. And that is simply analysed on the basis of when did you receive the material and when have you eventually turned it over to the defence. Now, the problem here is that we get a very clear statement from the prosecution at the 13th status conference on the 13th of July, and Your Honour summarised it accurately in opening the point. We're assured at that point that the exculpatory review has taken place. The documents have been disclosed and reviewed and disclosed, both. What remained, Mr. Halling said on that occasion, was vigilance. Vigilance. 304 items come out of the woodwork after that point. These are not short items. We've put them together. We think 8,000 pages odd, given to the defence in batch 418. I do stand by the submission that the documents include documents that are obviously exculpatory. It is baffling to me that anyone in the prosecution can have reviewed some of these documents and not realised they were exculpatory. We have statements, and I don't want to go into the detail in open session, but there are statements from KLA members of units who are asked about the role of general staff and who respond that they were very much independent of the general staff. They are asked whether the general staff, whether they had to inform general staff before taking part in an attack. Response, no. Anybody looking at that, anybody knowing the issues in this case would immediately see it's exculpatory material. which should be turned over to which should have been turned over to the defence immediately, and it was not. So on the short issue of whether there are still violations of 103, we say clearly there are. This has been before Your Honour already. Your Honour has already found that the prosecution have not been fully diligent. Those words were used in our filing, but quoting directly from Your Honour's recent decision on the matter, Your Honour has already strongly urged the prosecution to abide by its obligations in the future, and we obviously echo that. We would urge the prosecution to use the review that is coming up, that Your Honour rightly ordered, as an opportunity to genuinely look at their processes, to see what has gone wrong in the past, and to make sure that it stops happening. Because we need this material. We needed it months ago. My client's been in detention for 22 months whilst we wait for this material, but it should not carry on happening as the pre-trial phase draws to a close.
Thank you, Mr. Ellis. I will give the floor to the prosecution, but before that, we will make a very short break. We will stay in the courtroom. It is for the audiovisual technician to check the internet connection with the DMU to make sure that the transmission is functioning well. So let's wait for 1 or 2 minutes. We'll see if we need to break for a longer time, but at least for a couple of minutes now. Thank you for your patience. And I invite the Madam Court Officer to update me as soon as you can on this issue. For the record, we are reconnecting with the DMU. And I hope this time everything will be working properly. So I'm told that the connection seems to work well now. As I mentioned before, I invite any party or participant to indicate if there is a connection problem on their side. But now we're going to resume the hearing. Mr. Prosecutor.
Thank you, Your Honor. We don't really have that much to add beyond what we've said already. But just to say, we take Rule 103 very seriously. We take the word immediately in that provision very seriously. And the premise of how this latest disclosure package occurred, items that had been reviewed once, but which we are in the course of the Rule 102.3 review checking them again, is proof that we are taking this seriously. We want to make sure that it's done right and that everything is in order for the defense so that they are prepared for trial. And we wanted to say that again today and just ask that some perspective be given. There were 280 items of the kind I described in the last package. There were 67,000 items selected by the defense on the Rule 102.3 notice. We understand that there's interest in our methods on Rule 103, and we will revert back to the pretrial judge on October 7.
Thank you, Mr. Prosecutor. I invite the SPO to give detailed explanations about the reasons why this disclosure package was disclosed after the deadline in your report that I expect before the 7th October. And we will take it from there about this disclosure package. Let us now move to the Rule 102.3 material. I remind the parties that at the last status conference held on 13 July 2022, I did not change the deadline of 30 September for the SPO to submit protective measure requests, to challenge materiality of the evidence, and to disclose all material not subject to protective measure requests or materiality challenges by 30 September 2022. In the last status conference, I also ordered the SPO to supplement its Rule 102.3 notice by 7 October 2022. Since the last status conference, the SPO indicated that it has disclosed over 12,300 Rule 102.3 items in response to defense requests, not including redisclosures. According to the SPO, approximately 80% of the total number of selected Rule 102.3 items across defense requests have now been resolved, leaving just over 11,000 unique items remaining to be disclosed. The SPO indicates that it will meet the 30 September and the 7 October deadlines. I also note that inter partes discussions on materiality have led to the withdrawal of defense requests in relation to some of the Rule 102.3 material. I thank the parties for their joint efforts on this matter, and I invite them to continue these discussions inter partes as much as they can. The SPO indicated that it anticipates making materiality challenges for fewer than 400 of the over 67,000 items selected by the defense. According to the SPO, applications on materiality and for protective measures will be submitted on a rolling basis whenever possible. In its submissions, the Selimi defense recalled the necessity for the SPO to provide consolidated spreadsheets for the individual Rule 102.3 requests once completed, tracking where particular items might have been disclosed, especially under a different rule. The Selimi defense also requests that I order the SPO to provide, at the very least and as soon as possible, an approximated figure of the expected materiality challenges and to which defense team or teams these challenges may pertain, and to bring forward the deadline so it is sufficiently in advance of the defense pretrial brief. The Krasniqi defense also requests the SPO to engage on materiality and protective measures issues sufficiently in advance of the deadline so as not to disrupt the ongoing timetable. I invite the SPO to indicate if it is able to start filing at least some of its materiality and protective measure requests before the 30 September 2022 deadline. In its written submissions, the Veseli defense also raised the issue of the disorganization of the case file, notably the unavailability of translations and the lack of link between the evidentiary item and the translation of this item that already exists in legal workflow. The Veseli defense underscores the impossibility of the task of assessing a case file of this size, where translations of important documents are not available or not readily apparent, and descriptions and other metadata are incomplete or inaccurate. I invite the SPO and the registry, if necessary, to indicate how this translation issue can be solved, especially how to make sure that translations that have already been made can be easily accessible for the parties. Mr. Prosecutor.
Thank you, Your Honor. Your Honor summarized our submissions accurately. In terms of the overall pace to be able to meet the 30 September deadline, we remain on track. The only issue that arose since our written submission, I would barely even call it an issue, but just a report, is that certain of the Thaci defense's Rule 1023 requests submitted before the 30 September deadline was set, one of which joined by the Krasniqi defense, they're incomplete, and that they indicate topics that they're interested in without actually specifying the items on the Rule 1023 notice. We reached out to the Thaci defense last week about this matter. No complaints were raised. They said they would get back to us this Friday, and that's fine. As long as the items are provided by Friday, we fully expect to be able to provide them by September 30th. In terms of the point about providing an approximate figure for materiality challenges, we gave one in our written submissions. We were anticipating a maximum of 400 items. It may drop more depending on inter partes correspondence, but we tried to give a conservative number of the most it will be. In terms of against which defense teams the materiality challenges will be directed against, it will generally be argued that the item is immaterial for all 4 defense teams. This was not a question asked by Your Honor in the status conference submissions order, but if you're interested in how many items we're projecting for protective measures or withholding that haven't been filed yet, we're estimating about 350 further items. As to the question about whether at least some protective measures requests can be filed before 30 September, yes, this is what we're trying to do. We're hoping even to have one by the end of next week, just to sort of start them going, and we remain confident that we can do them all by the 30th of September. As to the points made by the Veseli defense about the case file, the SPO is providing all of the information in its disclosure metadata that it's statutorily required to provide, and the Veseli defense's own submissions do show that they are able to make links within the record. There are actually no examples in the Veseli defense's bullet points provided of any inaccurate metadata, contrary to what's said in paragraph 7 of their status conference submissions. And in the second bullet point in their submissions on this point, they actually say that there are 2 items that are linked to each other that in fact are not. If you look at the first 2 ERNs in paragraph 6, bullet point 2, they're actually 2 different items that were correctly not linked. They even have different dates. Even without knowing Albanian, you can see this. As to Your Honor's question about translations, we are providing linked translations whenever we make them, whenever the SPO makes the translation, they're always linked. And for all items where we are obliged to provide a translation. And we are making those links in the relations field in legal workflow. We are also linking every translation in legal workflow when we have identified a link. And one caveat in this regard is that unless we have made the translation ourselves, we are generally not making links for partial translations. We think that precision is important in this regard, and we aren't going to link two documents together if one is only a partial of another and there's a translation. And some of the Vesely defense's examples are talking about two items that actually aren't exactly the same, and that explains why links aren't created. The ERNs themselves also create a link, especially for the translations we create ourselves. Just as an example, the filing where we have the ET at the end of our ERN ranges, that is always linked to a base ERN of some other documents with an AT or with no marking of that kind. These are also links made in the record. There are actually over 4,500 disclosed items with an ET designation. So we are linking translations when we can. We are, as we've said before, we're not under any obligation to translate all Rule 102.3 materials for the defense. And we're not obligated to identify duplicate information that might be within parts of them. We have agreed to disclose translations when we have them, but at the end of the day, it's for the defense to organize this material.
Thank you, Mr. Prosecutor. Mr. Kihu, please.
Yes, thank you, Your Honor. This, of course, is an ongoing issue that's been going on for well over a year on these disclosures. Yes, there have been disclosures of 102.3 material. With regard to the requests that we have made, 34% of our requests remain outstanding. That's well in excess of 6,300 documents have yet to be released. And that, based on what counsel just noted, are going to be disclosed by the 30th of September. It's interesting to look at these individual issues parenthetically, and I certainly understand why Your Honor does so, but I'm sure you understand the difficulty with getting this amount of material in conjunction with hundreds of 103 documents that they disclosed on the 31st of August for us to digest and go through and argue on materiality and still meet the 21 October 2022 deadline for our pretrial brief, which we will make. That is a very, very difficult endeavor. Now, to the extent that they are willing to address all of these disclosures, these 102.3 disclosures, on a rolling basis, I urge them to do it now so we can address materiality issues and get that information to us. So if it's of use to the court in our pretrial brief, the court will have that document and our explanation. So we have engaged on materiality issues. The prosecution has come back to the Thaci team on one materiality issue, and we withdrew that materiality request. The other request counsel was just speaking of, we are responding tomorrow. There will be a push. We request for some of those documents and a withdrawal of other documents. So we will work through this issue. But to get all of this dumped at the 11th hour on the 30th of September, albeit within the deadline Your Honor laid out, and plus incorporated into the 21 October deadline for our pretrial brief, I'm sure you're going to understand, Your Honor, is challenging, to say the least. So nevertheless, at this point, if we could get as much of this material on a rolling basis as quickly as we can, that would be very helpful for all parties, but most helpful for the court as we're putting together our pretrial brief. With regard to the translation issue, I'll leave that to my colleagues on the Vasily team to address. Thank you, Your Honor.
Thank you, Mr. Kihu. Ms. O'Reilly, please.
Thank you, Your Honor. The main issue here is that the prosecution doesn't actually seem to know what they have. And that's, I mean, this is, yes, there are organizational issues, which I'll get to in a moment, but they were supposed to put the indictment together based on the evidence, both the inculpatory and exculpatory evidence. And it appears from looking through their disclosures that they don't know the entirety of the material. We're still getting 103 information. So that's, I mean, that's the real concern here, is that we are continuing to get 103 information that undermines their indictment, that they apparently didn't know they had 2 years after the indictments were issued. But like, as to the organizational issues, I'll just say a few points. First of all, as to us not actually including any examples of inaccurate metadata, I might refer Mr. Holling to the email we sent the SPO 2 days ago about inaccurate pseudonyms. There are plenty of examples of inaccurate metadata to be had, but that's just one of them. As for partial translations, not being linked because they're not exactly the same document. All I can say is it would be very helpful to us if the partial translations were linked, and I'm actually sure helpful to the prosecution as well. Mr. Holing said in relation to his submissions on the 103 evidence that he wants to make sure that everything is done right and everything is in order for the defence so that we can commence trial. I don't understand why that applies to 103 disclosure but not to 102.3 disclosure. I'll leave it there for now, Your Honour. Thank you.
Thank you, Mr. O'Reilly. Mr. Young, please.
Your Honour, thank you. Your Honour, well, we are, first of all, let me say, we're grateful for the figure. At least we asked for a figure, and we've now got a figure. We have a figure of 350, which is some progress, but it's an alarming figure, particularly at this stage of proceedings. As Your Honour will know from the wording of Rule 102.3, the last sentence reads, the specialist prosecutor shall immediately seize the panel where grounds to dispute the materiality of the information exist. Well, now we're on notice. Now we're on notice in September 2022 that there are going to be materiality challenges for a very large body of materials, which on the face of it will involve extensive litigation. So it's helpful to know for our planning and resource purposes, but Your Honour may be alarmed by that figure because it will take some while to litigate these issues. Thank you.
Thank you, Mr. Young. Mr. Ellis, please.
Your Honour, as it stands, we welcome the indication from the prosecutor that they are going to comply with the deadline by the 30th of September. Of course, there's not going to be another status conference between now and then. So if there is going to be any issue with regards to that deadline, we very much hope it's going to be identified today in open court in public and not in a filing shortly before that deadline. As best as we can assess the figures, and for all the reasons identified in our filings, it's difficult for us to know exactly how many items are outstanding. Items are split when they are disclosed to us. Additional translations are provided when they are disclosed to us. As best we can tell, we think we're waiting for at least 12,500 items still to be disclosed. And putting that in context, if the prosecution has disclosed 12,300 items since the last status conference in 7 or 8 weeks, clearly there's going to be a significant surge in the pace of disclosure in the next 3 weeks. Having said that, we note the submission that the prosecution is on track. I'm sure, like a long-distance runner hearing the bell as they round for the last lap, there is even now a sprint for the line in the prosecution disclosure team. This was, of course, a deadline that they themselves suggested. Much of this material we've been waiting for many months. In September 2022, we've had disclosure batches relating to our third Rule 102.3 request, our fourth 102.3 request, the fifth, the sixth, the seventh, the eighth. It's all coming together in rather a haphazard manner. We look forward to it being completed, Your Honour.
Thank you, Mr. Ellis. I think we all note from the disclosure packages that are notified on legal workflow that disclosure is continuing. So I hope, Mr. Prosecutor, that you will not wait for the 30th September to disclose the 11,000 documents, but you will continue to disclose them on a rolling basis. Can you reassure the defense for this? I've actually seen that you disclose probably 7 or 8 packages today between 11 and 1:15.
Correct. Yesterday as well, Your Honour, and we'll continue to do so.
Thank you, Mr. Prosecutor. Mr. Nielsen, is there any way to help the defense with the issue of translation? Because I understand that if it's not the same document, the prosecution does not want to make any link, but is there any way to help the defense to identify when at least part of a document has already been translated?
Thank you, Your Honour. it might be difficult for the registry to do it because we are not familiar with the documentation. So we would most likely will have to turn to the specialist prosecutor's office to get the relevant information. So I'm not sure we will be helpful in that respect. If there are somehow on an exceptional basis documents that are not translated and needs to be translated on an urgent basis, we'll endeavor to assist as much as we can, of course. With regard to specifically with regard to the linking of the originals and the translation, the feature is there, as my colleague has indicated, and it's being used as well. To the extent there are any technical problems with it, certainly we will be able to assist with that. We have received no reports or complaints about that particular feature of it, and there has been no indications today that there are any problems with it. So, yeah, that's as far as I can take it, Your Honor.
Thank you, Mr. Nielsen. I don't see any party requesting the floor. So we will move to the Rule 107 material. At the last status conference, the SPO indicated that there were approximately 400 items for which clearance decisions remain pending. I note the SPO's submissions that it has made significant progress with a specific provider since the last status conference, securing clearance for half the pages provided with Rule 107 restrictions. The SPO also indicated that the other half of these pages is scheduled to be processed by the provider by the end of September 2022, and that once this occurs, there will be less than 50 Rule 107 items whose clearance remains outstanding. In its written submissions, the Krasniqi defense requests that I set a deadline for the completion of Rule 107 disclosure, while the Selimi defense requests that I direct the SPO to provide not just a status update on the requests, but also a specific breakdown of the nature of the documents in terms of which disclosure rule they fall under. So I invite the SPO to give clarifications, especially if it's possible, on the last questions of the Selimi defense in its oral submissions. Mr. Prosecutor.
Thank you, Your Honor. And yes, again, as seen from our written submissions, we are continuing to make good progress. There's always the issue that it's not fully within our control, how quickly we can make that progress, but that is indeed the estimates that we have given. Cleared Rule 107 items in terms of kind of rough categorizations of what's being cleared and what remains to be cleared, they're generally going to go on the updated Rule 1023 notice, or if they're cleared after 7 October on whatever the next updated Rule 1023 notice will be. There are very few items within the uncleared group. I think it's even less than 25 that have any sort of Rule 103 content. Consistent with our statutory obligations, as soon as those Rule 103 items are cleared, they're disclosed immediately.
Sorry, Mr. Prosecutor, so that it's very clear for all the parties, when you talk about the uncleared group, you mean the 50 that will remain at the end of this month, hopefully, or you mean the 400?
I mean the 400, Your Honor. So, I mean, including the items that were recently cleared and the ones we're hoping to have cleared but have not been cleared as of this moment.
Thank you for the clarification.
Yes, and so unless Your Honor has any other questions on the progress of that, those are our submissions.
Thank you, Mr. Prosecutor. Mr. Kihu, please.
Yes, Your Honor. What is not clear to us is the volume of these documents. And Your Honor has been talking about documents. Well, in various items, the SPO has talked about pages and documents. Are we talking about 50 documents? Or is there some other large number of pages? And that is clear. That is not clear to us based on some inconsistencies in those descriptions. So we would ask for a clarification. Obviously, it's 107 material, so we're a bit in the dark as to the nature of that. And what also remains outstanding, and this is outstanding, I believe, since July, the SPO has asked the court to relieve it of its Rule 107 obligation or disclosure obligations of a certain amount of documents. certainly, Judge, and we haven't seen these documents, if these are Rule 103 documents, that is certainly going to be done. Any decision to limit their disclosure obligations is given to the prejudice of the defense. Again, we're in the dark about what these documents say, if they are Rule 103, et cetera. So if there is some methodology for some in-camera examination by the defense in conjunction with the court as to whether or not we can even make a Rule 103 a request of the court, we would welcome that procedure in any fashion Your Honor would have to safeguard the Rule 107 provider and to not disclose this to any other individuals, at the same time safeguarding the rights of our clients. Thank you.
Thank you, Mr. Kihu. Ms. O'Reilly, please.
Your Honour, I've nothing particular to add except that we would support a deadline, and indeed would have supported a deadline some time ago. Thank you.
Thank you, Ms. O'Reilly. Mr. Young, please.
In fact, to Mr. Tully, no, thank you.
Mr. Telly, please.
Thank you, Your Honour. I'll be very brief, and I'm grateful to the prosecution for the clarification they've given us in terms of the categorisation of the items. But to just be a stickler, I have noticed that Your Honour has some problems with clarity as exactly what's going where. We share your pain. I also noticed that the answer that Mr. Halling gave was somewhere roughly around 25. If we can get the exact number and a little bit more specificity on exactly what's going to be happening, because, Your Honour, the way it is at the moment, with the number of items that have now been discussed in terms of Rule 102.3, if I'm correct, we're talking about 400 items for materiality, and I believe the figure of 350 further items for protective measures was mentioned. Now, just not to go back on the same issue that was already discussed, but with the materiality challenges, we will attempt to deal with that inter partes. The last process was very smooth. We hope the next one can be as smooth. But looking at the timing, those plus the 25, which might not seem like a huge amount of numbers, becomes a very big number when you're talking about 3 weeks before deadline or 1 week before deadline. I don't want to talk too much about anything that sounds like a sob story, but we are of limited resources, Your Honour. It's traditionally the way it is. The defence, we allocate our resources based on need, based on upcoming plans, deadlines, etc. So knowing with any bit of clarity what's going to come down the pipeline, because I'm getting quite nervous seeing these large numbers, then we can move around internal deadlines. And on that, I note that in the SPO's submissions in relation to Rule 102.3, they said, quote, the continued feasibility of estimate importantly depends on no new resource-intensive obligations compromising SPO's progress. Well, that cuts both ways, Your Honour. We're in the same boat, and we're not asking for resource-intensive obligations to be enforced on the SPO. And I know we asked for an order, but to be honest, clarification by email by the end of today or by lunchtime tomorrow, I believe would be reasonable. They categorized the documents months ago, years ago. They should have that number at hand, and we would like to receive that within the next 24 hours. Thank you, Your Honour. Those are my submissions.
Thank you, Mr. Tully. Mr. Ellis, please.
Your Honour, we stand by our request for a deadline. Our thinking is simply this. The pre-trial phase in this case has now been going on for 22 months. For all of that time, our clients have been in detention. We need matters to move on. We're determined to meet our 21st October deadline for the pre-trial brief. We would like to be able to use the Rule 107 material in that. At every status conference, we have heard that the prosecution are actively working on obtaining the clearances, going back to the very first status conference, if minds can stretch back that far. We would say the time has come to give a deadline for this, and we would like that as a practical way of moving forwards.
Thank you, Mr. Ellis. I'll give the floor back to the prosecution. Mr. Prosecutor, are you able to give further detail, especially about the number of pages for the Rule 107 material, to give a little more specificity, as was requested by the Salimi defense? And more generally, because I think what Mr. Tully said is actually a good summary of what will be left to be discussed towards the end of September. In fact, we have 800 items for which there will probably be a discussion, inter partes or before me, which is 400 items for materiality, 350 for protective measures, and 50 for Rule 107 clearance. If you can also give the defense an idea of the number of pages for each of these categories, I understand you cannot do it immediately, but either after the break or as suggested by Mr. Tully, by tomorrow, I think this would be much appreciated by not only the defense, but probably everybody in this courtroom, especially for planning purposes. Mr. Prosecutor.
Thank you, Your Honor. We'll see what we can do to get some numbers together that we can actually share. The only thing I think it's understood, but just to clarify, the 400 and the 350 numbers are unrelated to the Rule 107 items, and the Rule 107 items are themselves unrelated to the 30 September deadline. So these are all things that are going to appear on an updated relevance list once cleared. And again, we're also hopeful of what's happening in September, but hasn't happened yet with the larger information provider.
And if I may also add to what I said, that I think the defense would be interested to know the number of pages for the Rule 107 documents that you will obtain clearance for until the end of the month, because that also is, I think, something to factor in, because those are not neither in the 400 for materiality, 350 for protective measures, and of course not for the 50 that will be remaining.
We can endeavor to send an email to the defense teams, and we can CC Your Honor's legal staff with what statistics that we're able to give, and we can do that by tomorrow.
This is much appreciated. Thank you, Mr. Prosecutor. I don't see any request for the floor, so we will move now to the SPO updated witness list. At the last status conference, I ordered the SPO to file a witness list which updates the mode of questioning and presentation time for each witness. On 2nd September, the SPO submitted its revised witness list. The SPO's overall case is now 7 and 9 hours, and there are now 196 proposed Rule 154 witnesses, and 83 more are proposed to provide evidence entirely in writings, and applications to introduce these materials will be filed before the trial panel. I invite the SPO to give any further details if necessary. I also note that the Vesely defense reiterates its requests for the SPO to provide the defense with, first, the first 32 witnesses it intends to call in the order it reasonably expects to call them, and second, the first 107 witnesses it intends to call. The Selimi defense also requests that I order the SPO to provide a provisional list of witnesses without prejudice to further amendments or variations for the first 3 months of trial and within a set deadline. According to the Selimi defense, such a list would allow the defense to organize and focus its investigative efforts on a compartmentalized group of witnesses out of the hundreds currently listed for appearance by the SPO. In the last status conference, the SPO indicated that it was not in a position to give this information at this stage. I invite the SPO to indicate when it would be able to give this information to the defense. And finally, the Selimi defense also indicated that it remains unclear to the defense whether or not the SPO has made every person on its witness list aware of the fact that they are to be called as SPO witnesses. And the defense requests that I order the SPO to make this notification at the earliest opportunity and within a set deadline, or is the alternative to clarify whether and how many of its witnesses have been informed of this fact. I invite the SPO to give clarification on this question as well. Mr. Prosecutor, please.
Thank you, Your Honor. Let me take those in order, and I believe I can be relatively brief for a number of reasons. First of all, I don't believe at this point there's anything to add to the submission, the written submissions we made in respect of our witness list. Second, with respect to the inquiry concerning advance notice of the order of witnesses, as the court indicated, that's a reiteration of a request that was discussed on several previous occasions. So I think I can be concise in identifying what was said before, and the bottom line on that was the prosecution noted the various factors militating against such a request, and the fact that the untimely and ill-founded nature of that request was reflected in the practice of every comparable institution, which only provided for such a provision after the matter had been transferred to the trial chamber, because that was the time at which the various uncertainties which made the provision both unfeasible and in fact irresponsible would be resolved. So our response is still consistent. The timeliness is still tied to the transfer of the case to the trial chamber when those issues can be resolved. Insofar, Your Honor, as the issue of whether or not the prosecution has notified those on the witness list of their position on the list, I would note, well, we may have done before, but I'm not sure if it came up, there's clearly nothing in the rules that calls for that. The justification offered by the Salimi defense, I would say, is clearly speculative, and I would even suggest counterintuitive. As in previous cases of this size and nature, there may well be some witnesses whom the prosecution may choose to summons to appear as witnesses when that time comes. But in any event, how and why the prosecution chooses to manage its witness list, I think has always been within the province of the prosecution and should remain so. Thank you, Your Honor.
Thank you, Mr. Prosecutor. Mr. Kehoe, please.
I believe that it is an alarming statement that in fact there are a litany of witnesses that are on this witness list that have no idea that they are on the witness list. You know, prior to the witness protocol, I can tell you to a person that none of the witnesses that we spoke to knew that they were on any list whatsoever. So that is where we are with regard to the communication between the SPO and witnesses that are in the field. The second issue with regard to the witnesses themselves, obviously, it's an interesting list, and if you look at the list, one might think that there are 326 witnesses, and if based on the list that was filed, and if you went to that conclusion, which I initially did, you and I collectively and everybody else would be incorrect, because there have been numbers removed without any recounting throughout this document. So if you look, for instance, at the first page, we jump from witness 21 to witness 23, and somehow witness 22 is no longer on the list, but is still part of the accounting to 326. And the same is true throughout this document as a whole. The document, it of course, maintains at this point, and I don't know if this is the subject of Your Honor's inquiry of counsel that hasn't been spoken of, but we are still talking about 709 hours of trial time for the prosecution's case. And if I go back to, hearken back to Mr. Emerson's numbers that he gave to Your Honor some time ago, for instance, on the Milosevic case, I believe that is double the time that that has been set forth by Mr. Emerson in his explanation of exactly, you know, what is going on with this particular witness list. If you look at what the prosecution has filed publicly, I might add, they file everything else under seal when they don't want to talk about things that are uncomfortable, but when they file this document publicly to talk about where they are here, they attempt to give some explanation why they need to be more expansive in their time as need be, at the same time refusing to give the defense some idea of where they plan on going for the first 3 months of trial. I mean, I ask this question rhetorically for a case that has been going on for years, literally years, that the prosecution doesn't have any idea approximately of the first 3 months' worth of witnesses that they plan on putting on. I find that, having been in this business for 40 years on both sides of the aisle, inconceivable. Of course they know who they're going to call. Of course they have an idea. That doesn't mean there can't be additions and deletions. Someone's ill, someone can't make it, someone passes away, God forbid. We all have been through those instances and trials. But the fact that they don't have an idea or can't tell this court and the defense who they're going to call, or have no idea who they're going to call in the first 3 months, is inconceivable. I would welcome, as an aside, if I may, Judge, I would welcome at least their admission that they now admit that they are trying the Kosovo Liberation Army. In paragraph 33 of this document, they note that the Kosovo Liberation Army operates a secret non-state actor behind its public face, consistent with what they wrote in paragraph 35, then contrary to comments in this courtroom, that in fact it is the KLA itself that's on trial. And what's disturbing about this document, Judge, after everything that has happened and all of the submissions that we have made to Your Honor concerning pretrial release, and mind you, once again, we're already an hour and we haven't brought this up. Our clients have been in custody since November of 2020. The prosecution has the temerity to say in paragraph 4, many significant witnesses in this case are loyal to the accused or are intimidated and afraid to testify. And I'm sure, based on that allegation like that there would be a footnote of information, that there would be something at the bottom of the page. They have a lot of footnotes here, Judge. Is there anything in this document to support that specious allegation that witnesses are afraid and intimidated and are afraid to testify in this court? Certainly, Judge, if that had come before the SPO in the 2 years, almost 2 years, that our clients have been in custody, it would have come to your attention. No. It's never been brought to your attention. It's never been brought to anyone's attention because it didn't happen. But they put it in a public document and don't expect anybody to react to it while trying to prejudice our clients while they're trying to prepare this case. And how about this one, Judge? As far as their time that they need. Victims have been waiting over 20 years to tell their stories before the court. They cannot be deprived of this opportunity simply to hurry the proceedings. Our clients have been in jail since November of 2020. Hurry the proceedings? And what, they plan on going another several years in trial because the victims have been waiting 20 years to testify? P.S., Judge, some of the witnesses that they have on this list have testified 7 times. 7 times. And they've testified in international courts. Several of these witnesses have testified in the ICTY, the UNMIC. They testified in the ULIX courts, both in Kosovo, and they're testifying here. That's 4 international courts, putting aside the domestic courts in Kosovo. So meanwhile, they're attempting to lay this horrific blame on our clients, cite nobody, bring nothing before this court about it to justify it, except to smear these men, and then say, oh, we need more time, Judge, because everybody's been waiting a long time. That's the justification. Our clients are waiting a long time. And who took 20 years to bring this case? Certainly not our clients. And who took even years since this institution has been put forth to bring an indictment before Your Honor to be verified and to be submitted? The SPO, not these defendants. So I take great umbrage of the position that the SPO attempts to put forth before this court, that somehow they shouldn't be delayed and somehow there has been some intimidation of witnesses by the accused and somehow they should be given more leeway than they already have to bring this case. I don't want to go any further on this, Your Honor. I can talk about this document at some length, but I know Your Honor's got some other pressing needs to talk about. Thank you.
Thank you, Mr. Kihu. Mr. Emerson, please.
Emerson, thank you, my lord. I'd like to take up just one aspect of the submissions that Mr. Kehoe has just made to you, and then deal with two other short points, if I may. Leaving for a moment aside the allegation of intimidation, the unsubstantiated, unalleged allegation of intimidation, so far as the defence are aware, of witnesses, one of the themes that runs heavily through the SPO's written submission is the suggestion that out of loyalty to the accused, some of the witnesses that the prosecution wishes or intends to call will be inhibited from testifying by, quotes, a code of silence instilled over time. And based on that, the suggestion is that many significant witnesses in this case who are loyal inescapably would be reluctant or unwilling to testify or acknowledge other prior statements and so forth. And in support of their submissions, there's a footnote reference both to President Thaci's interviews describing lack of organisation within the Kosovo Liberation Army, and to Mr. Vasili's statement made on arrest and referred to in open court at his first appearance. And the passage quoted says, "I'm confident that when the judges have heard all the evidence in this case, they will conclude beyond reasonable doubt that the Kosovo Liberation Army was a people's movement, an uprising in self-defense with brave men and women doing their best in almost impossible circumstances, without formal structures, to protect the civilian population against a carefully planned and genocidal military onslaught by Serbian forces." Now, the O has chosen not to cite from that statement was Mr. Vasili's very clear message to those within Kosovo who might be tempted out of misguided loyalty to withhold their cooperation, that he sent a very clear and explicit message to them that all should cooperate with these chambers, with the Kosovo specialist chambers, and no one should think that withholding their cooperation was a course that was assisting the accused. And he, having seen this written submission referring to codes of silence, loyalty to the accused, and therefore an inevitable reluctance to cooperate, he has asked me specifically to reiterate that part of his statement made following his arrest and at his first appearance, that he calls upon those whose testimony is required or requested to be brought before this tribunal to cooperate in every respect. And it's absolutely necessary to correct the record in that way, because selective quotations by the SPO designed to build a skewed and unfair impression of the situation as this case is closing its pre-trial stage and ready to be brought before the trial chamber, it's not what one would hope for from the best of prosecutors, let me put it that way. The other aspect which rather reinforces this relates to witnesses who are not being called and witnesses who are proposed to be called. But can I deal with those under my submissions on the overall structure as it is proposed? So Your Honour's already pointed out that the SPO now proposed to reduce the number of hours within which it calls the same case. And it's been the prosecution's position for at a number of status conferences that it will not countenance any reduction in the scope of its case to make this trial manageable, but instead will fiddle, no, that's not the right expression, I apologize, instead will make decisions about the modes of testimony to be used in order to present something which appears a more realistic and reasonable time estimate overall. the net result is a reduction of what the prosecution says it will need in terms of oral evidence, having regard to the reliance particularly on rules 153 and 154. I like to place it on the record that this is very obviously a false economy, particularly as regards rule 154. The procedure, as your Honour will know, for 154 witnesses is that a written document is tendered and adopted, and then the witness is made available for cross-examination. The general practice in other tribunals is where a witness is made available for cross-examination solely on a document which has been tendered to stand in lieu of their evidence in chief, the defence are allowed approximately, if a rough time frame is used by the trial chamber, twice the time that they would be allowed if the witness had given evidence in chief and was being cross-examined. I mean, that may not be the approach that this trial chamber takes, but the point is the same, which is that what the prosecution, if you take one witness just in the abstract, a hypothetical witness, what the prosecution is doing is transferring to the defence the same time frame. So if the witness was expected originally to take 15 hours, let us say, the prosecution will now put them forward and take 5 minutes, or put them forward and take an hour, or maybe 2 hours, and then leave the defence the responsibility of eliciting the evidence in a manner which is properly tested before the trial chamber. So although the 709 result looks better than the original numbers, in reality, what they're seeking to do is to place the responsibility on the defence so that they can say, well, we kept within 700 hours. The fact that in reality it took twice or three times that long to complete the prosecution case, that's not our fault. We used rule 153. And so on any view, the economies that result from that are a chimera. They don't, in fact, reduce the length that it will take in trial terms for the prosecution's case to be elicited and examined. So it's a false economy. It's also it also presents a false picture of the extent of the case as it will necessarily play out at trial. It will inevitably be very much longer because of the methods that the prosecution is choosing to use. So I want to make that point now because the adamant determination not to adopt any focus in its presentation of the case, not to shape it or provide it in a manner that a trial chamber can get to grip with, understand what the prosecution is trying to prove, understand who are the main witnesses alleged to implicate each of the defendants in one way or another. Nothing has been done or is proposed to be done to promote that very obvious forensic objective of the trial process. Instead, we are still in the position where the prosecution throws everything, including the kitchen sink, into the prosecution case. And all it has done is rejigged the time as between the two. We remain as committed as we were before to the proposal that the prosecution should be allocated 1 year to present its case, and the defence 1 year collectively between the four accused to present the defence case. That is the only way that this trial can be made manageable, and a time limit has the inestimable advantage of forcing the prosecution to do the job it is obviously so reluctant to do, which is to critically examine its own case and put forward something which is forensically comprehensible and can be tested. So we don't see any significant progress in the steps that the prosecution outlined in this document. Indeed, it's a confirmation of a dogged unwillingness to assist the trial chamber to manage this trial. And so I'm not inviting Your Honour to make a ruling, because obviously this is a matter that is going to need to be addressed by the trial chamber in fairly short form, fairly early on after referral. But it would be completely wrong if I had failed to place on the record the analysis which we say follows inevitably from this, which is the prosecution has failed to hear the need to make this case manageable and is moving around the deck chairs on the Titanic in order to make it appear that the boat is still afloat. So that's the first thing. As turning to 153, we now have 83 witnesses whom it is proposed should be tendered in writing, but without giving any oral testimony or being cross-examined on behalf of the accused. Now, two things arise from that. One is, of course, the trial chamber has to allocate less weight to a witness who cannot be examined orally. That's the rules, that's the law. It doesn't mean that they are of no value, but it makes it extremely difficult to evaluate their testimony. The second side to that is that the prosecution's obligations of disclosure in those circumstances are much, much higher than in terms of a disclosure adverse to credibility than would necessarily be the case for witnesses who are being called to testify, because the prosecution must, and it again is the law, disclose to the trial chamber and to the defense anything that it has or could gain access to which might adversely impact the credibility of the witness whose statement they are tendering. Otherwise, they may not lawfully tender it. And that's crucial. Why the additional hurdle? Because since it can't be examined orally and the witnesses can't be tested orally, the prosecution must satisfy the trial chamber that the trial chamber and the defense have everything possible to evaluate what weight, if any, should be attached to the statement or transcript of a witness who is, for whatever reason, either through death or alleged intimidation. And so far, as Mr. Kehoe has said, there has been no allegation of intimidation. So we're slightly, we're interested to see what the basis for the 153 applications is going to be. And obviously, if somebody is dead, that's the basis for it. But it's witnesses that fall outside that category, where the prosecution is trying, in effect, to have the benefit of evidence of a witness without that witness being open to effective or indeed any challenge as to their credibility. So I lay down a marker there that if the prosecution thinks 153 is a simple route to pretending to have cut down its case, I'm afraid the reverse is true. There will be a far heavier duty of disclosure as regards those witnesses, and that must be performed now. It must be performed now because the trial chamber is going to need to decide objections to admissibility at an early stage. And objections to admissibility on Rule 153 evidence fall in two categories. One, has the prosecution disclosed everything, not just that it has, but that it could gain access to, that could adversely affect the credibility of the witness, number one. And number two, have they satisfied the requirements of Rule 153? And if so, how are they seeking to prove that? Now, we make it clear now, we make a general challenge, and we will be mounting a general challenge to all 153 attempts by the prosecution, requiring proof of the disclosure obligation and proof of the requirements of 153 to be cross-examined if necessary, if it's suggested that a witness was intimidated. And all of that evidence must be disclosed as soon as the case is transferred so that the proper challenges to admissibility could be made at the proper time. And then finally, the last point I wanted to make, and it's just a question of the flavor of the approach that's being taken and whether it has the feel of a prosecution that is being guided by its role as a ministry of justice. In other words, to help the trial chamber seek the truth, rather than as a partisan party to proceedings designed to skew the evidence at all costs in favor of the prosecution's thesis. So we have one witness, and I won't read out the cipher. We don't have a name, but I won't read out the cipher because I don't think it's helpful at this stage. for whom the prosecution proposes to allow 16 hours for testimony in chief. That's, I think, the longest witness that they propose to call. At the moment, we have a cipher and a vanilla 2-3 paragraph summary, which doesn't say anything. We have no transcript, and we have no detailed Rule 154 statement. Now, is this one of the witnesses that the prosecution thinks that it will need extra time for because they're unlikely to testify, and the hope is that they'll be able to prod them into? I mean, we have no idea. What we do know is that the prosecution is asking for the maximum time for a KLA insider witness for whom we have no meaningful evidence to assess. And that raises concerns about ambush. Is the prosecution here really disclosing its case, or has it held back this witness with 16 hours evidence in chief, who we, the defense, have obviously no opportunity to prepare for, in a manner which is less than consistent with prosecuting fairly? By the same token, the SPO has now dropped he might well support the defense thesis that this suggestion of a secret army within an army and the nonsense about there being a secret code and so forth, it is utterly divorced from the reality that was experienced by those on the ground. Now, it doesn't lie in my mouth, in principle, to be complaining that the prosecution has dropped witnesses, because that's what we think they need to do to make the trial manageable and real. But we are left with the overall impression, and I would invite, and I'm sure the trial chamber will read these submissions, will invite the trial chamber to note that the overwhelming impression is that prosecution still doesn't know what its own case is supposed to be, but is hoping for something to come up, and is therefore seeking to put everything possible in front of the trial chamber and see where the cards fall. But what they will do along the way is keep back secret witnesses, their longest proposed time estimate with no information to the defense enabling them to prepare, and abandon witnesses they know are likely to support the defense case. Is this the sort of conduct one would expect to see from a prosecution that genuinely was seeking to assist the tribunal to reach a just result, or one that is genuinely seeking to justify its own existence and the delay in which the case has suffered from? Those are our submissions, and my only submission for today.
Thank you, Mr. Emerson. Mr. Tully, please.
Thank you, Your Honour. I will deal specifically with our orders, the two that you mentioned, and you summed up accurately. I will not be as polite as Mr. Emerson, and I will jump around a little bit in the agenda, but just very briefly, I'd just like to note that you're raising this under the issue with regard to prosecution witness list for understandable reasons. But where we put it in our written submissions was in an update on the defense investigations, and there was a reason for that. As we have received from the prosecution's updated update in its written submissions for today, we have been updated on the redactions that we expect to face. Now, this is also an issue that will be dealt with later. I'm not going to deal with it in detail here. But we noted that our investigations, and this is a repetition of something that Mr. Roberts addressed the court on last time he was here in July, which is that our investigations are continuing well, but there are two main obstacles to that. The first one is that the obvious delay caused by the nature of the witness contact framework. I'm not going to relitigate that. I'm reliably informed by our hardworking evidence review assistant, Ms. Getzai, that our appeal will be on time. and also our extensive redactions also not being relitigated. But we did notice in the prosecution submissions that there are 10,000 new items expected 30 days before trial, and there are 36,000 documents that are affected by non-standard redactions. 30 days before trial, Your Honour, that's pretty close. I note Mr. Teager's point that there is nothing in the rules that forces them to do any of these things that we've asked for. We know that. There's a reason that we asked for your order, Your Honour. Under Article 3913 of the law, as I'm sure everybody is aware, but just for the benefit of the transcript, the pretrial judge may, where necessary, at the request of a party or victim's counsel on his or her own motion, issue any other order as may be necessary for the preparation of a fair and expeditious trial. So this is the context in which we're making these orders, all of the above in mind. So turning first to the renewal of our request for order on the notification of witnesses. This was asked by Mr. Roberts at the last status conference, and we didn't really receive a clear answer, hence our renewed interest in it. We are more interested in it today, having heard the prosecution's response. So we're not trying to badger the prosecution with the same type of requests over and over again. And Mr. Teager might not be impressed by them, but the delays we are concerned with, given the context in which our investigations are taking place, is that if witnesses are unaware that they are SPO witnesses, leaving aside the alarm that that causes Mr. Kehoe that we share, and the trial and our investigation continues, if a witness is informed and they don't want to testify, which out of the hundreds that we are talking about, that could well happen several times, the SPO must then decide to subpoena the witness, or the witness might decide that they're not coming, and the SPO might drop that witness for whom we've prepared and we've devoted our limited resources to go and investigate. This is the nature of the request. It's nothing more than that. There's nothing sinister about it. And we're simply trying to deal with problems before they arise during our investigations so that we can prepare efficiently for trial. Hence the reason that we're coming to you under your powers to issue such an order. One imagines that the request is pretty simple. They've chosen the witnesses. They tell us the witnesses are all coming. The case is ready to go. They're ready to sit 5 days a week, every week of the year, for as many years as it takes to have this case ready. Yet they still can't tell us if they've told all of the witnesses if they're coming. And all we asked for was clarification as to whether they did that or not. And they can't give us that. That to us seems suspicious and unreasonable, Your Honour. So turning to the provisional witness list, I'll be brief on this. The key word there is provisional. As we said in the written submissions, this is without prejudice to amendment, to subsequent change. We understand that it's difficult. We understand that this is early stages. But again, given the context of the redactions and the process we have to go through to talk to these witnesses, any type of clarification as to what areas of the hundreds of witnesses we should be looking in is well received. We might receive something and they say, this is 50% accurate, this is 40% accurate. Anything at all, because we are still in the dark. The constant theme of the submissions today have been clarity. We're in the dark so often on so many things that could easily be resolved. Yes, there isn't a rule to follow that forces them to do it, but Your Honour can make an order to make them do it. And one of the things that I will note is that Mr. Teagan mentioned various uncertainties that hamper their ability to give us this information. Well, one of the uncertainties that was mentioned at the last status conference, I believe twice, was the defence pretrial brief. Now, Your Honour, we can't take submissions like this seriously. The defence pretrial briefs will, in accordance with the rules, generally set out the case as required. It's not a document of notification of the case in the same way that the SPO or OTP and other institutions is. It will inform the nature of the case. It will fulfill all the requirements of Rule 95. But it cannot possibly be revelatory to a degree that it can hold up the entire process of witness selection, unless they're talking about alibi information, which, having investigated the case for 7 years, one would imagine they're well on top of. But nevertheless, I note that Rule 104.2 allows specifically for rebuttal evidence to the prosecution to do that, and that doesn't happen at the start of the case. Those are my observations for now, Your Honour. We renew and maintain our request for those orders. Thank you.
Thank you, Mr. Tully. Mr. Ellis, please.
Thank you, Your Honour. I will be brief because I want to adopt expressly much of what has been said before. In particular, I associate the Krasniqi defence strongly with the observations made by Mr. Emerson in his submissions on behalf of Kadri Vasili. On the issue of streamlining, what has happened is that the prosecution have come up with a headline figure saying that they've reduced their number of hours of direct examination to 709. What that does not reflect is the total amount of time that the prosecution case will take once cross-examination, re-examination are taken into account. It is, as Mr. Emerson said, very obviously a false economy, because what is going to happen is that the prosecution will try to introduce their evidence in writing, passing the burden on the defense to cross-examine for longer. And so what we are looking at, with still a witness list of 319 witnesses, I think, at the last count, it is still a trial that is going to take years, a prosecution case that is going to take years. It is not the streamlining that we were looking for. It may not be an issue that can be resolved today. It's classically a trial panel issue, but we place it on record now that this is not the reduction that was needed to transform this into a manageable trial. And we will, of course, respond to the 153, the 154, the 155 motions when they come in. We note the prosecution plans to make them to the trial panel. We'll respond at the appropriate time. Separately, we do not understand the submission that it would be untimely for the prosecution now to identify the first 30, 32 witnesses it intends to call. We may be in the pre-trial phase of the case still, but we are certainly not in the early stages of this case. We have been going for 22 months now. It is inconceivable that the prosecution do not know which witnesses they want to put on first. But what they prefer to do is to leave us with a list of 319 names, trying to prepare for everybody, without the focus that we could bring to the preparations if we knew who was coming first. It's an entirely reasonable request. We don't need to wait for the trial panel to be impaneled before looking at this. It will help everybody move this case forwards. Your Honour, there would be further submissions in relation to 1F on your agenda in relation to the number of pages of material to come 30 days before trial. But do I understand correctly that's a later agenda item? Okay.
Thank you, Mr. Ellis. Mr. Prosecutor, on the various points and questions raised by the defense, please.
Well, Your Honor, I don't know if I'll be able to address them all, and I don't want to address them necessarily in order in any event, but let me take a stab at it. Mr. Kehoe began by indicating that he was shocked to discover that the prosecution considered that there was a climate of intimidation surrounding this case. I think that's been an issue which has been part of this case from the outset in various forms. With respect to reflections of intimidation of any sort or reflections of loyalty, the materials that the prosecution has disclosed are replete with examples of that. It will emerge during the course of trial on various occasions, but it's no surprise to anyone, and I would suggest that to act as if this has come up for the first time by virtue of relatively anodyne observations in our submission is not an accurate reflection of where we've been up to now, and unhappily where we may be. The particular provisions in our submission that gave rise to the allegations that we were accusing the various accused, and in particular Mr. Thaci, of intimidating persons or calling upon their loyalty, were observations about the general nature of organizations such as the KLA and the birth of those organizations and the development of those organizations. Seems to me illuminating that to the extent it was self-evident, as we argued, that such organizations give rise to loyalties and that are reflected in silences in the face of crimes, that is seen as being the responsibility of the various accused. That seems to me something of a tacit admission of the role of the accused in those organizations. What the prosecution was saying is that the expectation of how this case will unfold when witnesses are called is informed by a number of factors, including previous cases, including the materials that we've submitted in support of the indictment, and that are statements of the various witnesses at which the defense has, and the logic surrounding such organizations. And the defensiveness of the responses to that submission is telling in itself. I wanted to respond to something the Vaselli defense said. I want to note that we went through a comprehensive and fairly painstaking review of the witnesses in order to arrive at the list we came to now. It wasn't simply a blanket conversion of the previous list. It was a reassessment. And the figures outlined in our submission are a reflection of that reassessment, no different than and it is no different than the kinds of witness lists that have been seen in comparable institutions in the past, and they have to be judged and assessed on that basis. So an attempt to characterize that as a mere sleight of hand transformation is, in fact, inaccurate. With respect to the overall scope of the case and the size of the case, I recall that some time ago, I think it was not the last status conference, but the previous status conference, the Vaselli defense made the point that the size of the witness list and the size of the case was a reflection of a prosecution effort to snow the trial chamber and the finders of fact with a list of horrors and thereby somehow mask the absence of evidence of linkage of the accused to the offenses. In fact, it's quite the contrary. Now, let me point out that in the Rule 86 3B submission of hundreds of pages in the pretrial brief, there is a litany of references and supportive material to various factors indicating the linkage of the accused to the crimes, including the fact that the general staff was at the very top of an increasingly organized structure, which was setting policy and giving orders from the very beginning of the indictment period, in fact, that the accused are driving forces within the general staff, that they were key figures in the formulation and implementation of the common criminal purpose, including through orders and oversight, but also that these objectives and their responsibility was reflected in the duration and extent of the implementation of the policy by subordinates of the accused. These cases, war crimes cases, cases of this type, are large not because prosecutors delight in piling on with many stories of tragedy and horror and blood, although unhappily that is part of the picture of these cases, but because the scale of the crimes is itself a key factor in demonstrating the existence and implementation of the policy through subordinates. And when you add to that the evidential requirements of establishing command and control and notice and ratification and other aspects of the existence of the policy, the cases are necessarily large, and you'll see that time and time again. There's nothing unusual about the size of this case. So I would simply underscore that the success of the post-Nuremberg efforts to combat impunity have been in large part because of a determination to overcome the previous idea that cases of this type could not be tried. They can be tried, they have been tried, and they will be tried, in part through the mechanisms of efficiency that have been developed over time. And in that respect, I want to respond to a couple of the submissions that suggested that Rule 154 was a false economy, because it's simply a transfer of the timing from one side of the courtroom to another. That has not been the case. It's not the case. You can follow the development of the trial procedures in cases of this type, and you'll see the increasing reliance in every institution on a Rule 154 equivalent because of its efficiency. And in formulating our list, we have been attentive to the best practices of those institutions. We've been and guided by their success, and that's what is reflected in our list. And to suggest somehow that every institution before now has been misguided and has been engaged in chimerical effort and fooling themselves about how much time has been consumed or saved by those procedures is false. With respect to the submissions about the order of witnesses, I think the Salimi defense suggested that acknowledged that there was nothing in the rules, and I would simply underscore there's nothing in the rules for a very good reason. And those reasons were articulated previously. It's untimely because there are many considerations that go into the formulation of a witness order that have not been resolved yet. Again, I don't want to get too deeply into it. That's been explained repeatedly, and the court is aware of that. And finally, in the time two more points. I'm sorry to be up here so long. I think the Vasselli defense juxtaposed, not for the first time, the heroism of many KLA members against the charges in this indictment. And I simply want to point out those are not mutually exclusive. This is the indictment and the fact that persons within the KLA use their positions of leadership to formulate and implement a particular policy, which was actualized through certain parts of their subordinate staff, does not gainsay in any way the fact that simultaneously people were fighting for a cause they believed in an honorable way. And in a related manner, I'd like to address a little more fulsomely than we have before the continuing claim that the prosecution has criminalized the KLA, is charging that the KLA itself is a criminal organization, that every member of the KLA is somehow a member of the joint criminal enterprise. That, Your Honor, is quite false for reasons that those who have advanced it in court know, or certainly should know. And let me explain why, and I'm sorry to take so much time. They've cited paragraph 35 over and over again. Now, first of all, paragraph 35 expressly makes the point that persons in the bodies mentioned who might have been JCE members might not have been at all and might instead have been used by JCE members and therefore not part of it. In short, it may be the case that none of the persons within those bodies were members of a JCE. And even the most uninformed but intellectually honest reading of that paragraph would lead any reader to that conclusion. But this is a standard pleading paragraph used in leadership cases over and over again that identifies the structures which may have included members or tools of the JCE. And I would suggest that anyone who practices law at this level knows that or should know about it. For example, the Sheshel indictment was one of many that essentially mirrored this pleading approach. Charged that Sheshel participated in a joint criminal enterprise, including Milosevic, Kadijevic, and others, quote, and other members of the Yugoslav People's Army, the Territorial Defense, the TOs of Serbia and Montenegro, and the police forces, and so on and so on. And Sheshel challenged this pleading, including with respect to the pleading of participants, and the trial chamber found that the form of pleading was both common and acceptable, and it found that the accused argument that the indictment included, quote, a few million participants was, quote, totally false and groundless. And on appeal, the accused, Mr. Sheshel, challenged the indictment and the joint criminal enterprise. The appeals chamber recalled that the trial chamber had addressed that and noted that his challenges were merely repetitive and accordingly dismissed his challenges to the indictment. Now, counsel for Mr. Vasselli, as we know, was a judge on the appeal. And as such, he himself confirmed that it is totally false and groundless to claim that this formulation embraces the entirety of the forces that may have included members of the JCE.
I'm sorry to interrupt, but this is completely inappropriate. First of all, I'm sorry, but I'm being introduced in open court. I'd like to have an opportunity to respond before it gets...
Mr. Emerson will have his opportunity.
You will, please. But Mr. Tigger, I invite you to be brief, and also we are not at trial, so I'm not asking for any argument regarding the JCE at this stage. We are talking about the witness list and the requests that have been made in written submissions by the defense, which have been discussed by the Selimi defense especially. So no need to enter this discussion about the JCE at this stage. So I invite you to be brief, Mr. Tigger.
Fine, Your Honor, and I will be brief. I also would have thought there'd be no need to address that. I raised this in response to what was said, not for the first time in this courtroom.
Not by me. I didn't say anything of the sort. Perhaps you'd like to look at the transcript.
And I did it in light of previous, in fact, multiple previous articulations of this false position, to my recollection, by virtually every team in the courtroom. So that's all I have, Your Honor. Sorry I took so long. Thank you for your time.
Thank you, Mr. Tiger. Mr.
Your Honor, I would like to comment just briefly.
So very briefly for each defense team, and I invite you to be very brief because we already at 25 minutes past the break for the interpreters, and we are not going to discuss about what should be discussed at trial. We are here to discuss about the witness list, and it's only if there is a link with the witness list that you are allowed to make any further submissions. Mr. Key.
And the link to the witness list is what counsel just said from his filing about this climate of intimidation, that reflections of loyalty that are replete through this. That's what they're putting in here, and that's what they just argued. But what's interesting, Judge, every time they got the opportunity to support their submission to you, Your Honor, in opposition to our pretrial release motion, and support those allegations, they refused. They didn't want an open hearing. They didn't want a hearing at all. They didn't want to put out for everybody to see what their evidence of intimidation was, what their loyalty reflections are throughout this, because, of course, the KLA is an organization that has its silences and its loyalties, but, we, the prosecution, aren't indicting the KLA under paragraph 35. Oh, we're just doing it in the submission before Your Honor. It's outrageous. That's the outrageous part that they are laying out here. This climate of intimidation, this climate of evil that they want to permeate this trial for, and when they're asked to put it before the court, they don't do it. And to the extent they give anything to Your Honor, they put it in a confidential document. Was this document confidential? No. No. Why? And why every time we press them to bring forth this climate of intimidation information so our clients could be released, did they refuse? It's quite simply because they don't have it. And God forbid they should bring exculpatory information, Rule 103 information before Your Honor that we've addressed before. We won't go. Why is this information that is potentially even-keeled and helpful to the defense never brought before your court? It does raise one's eyebrow, does it not? Everything that Mr. Emerson noted before should raise one's eyebrows at the perspective that the OTP, that the SPO is taking in this matter. I know Your Honor doesn't want me to go on extensively, and I will cut short my arguments, but their position on this intimidation and this climate of fear is outrageous because it's unsubstantiated, and anytime they're given the opportunity to substantiate it, they don't do it. And again, they did it again, because when they put it in this pleading, what did they cite? They cited a lot of other things in the footnotes, but didn't cite any support for that.
Thank you, Mr. Keogh. Mr. Emerson, briefly, please.
Very, very briefly. I'm not going to respond to Mr. Tiger's tendentious submission comparing the KLA to the Serbian genocidaires, but I would simply say, leaving aside paragraph 35 that he found himself trying to rely upon in the Sheffield judgment, paragraph 3 of the submission about the witness list reads as follows, and it's signed by Mr. Smith. The Kosovo Liberation Army operated as a secret, non-state actor behind its public face. That is the essence of the submission that was being dealt with. And I certainly didn't make any submissions in relation to it. Now, as far as the substance is concerned, I'd just like, perhaps we can all take some time in the break, but I would just like to, first of all, invite Your Honor to consider asking Mr. Tiger, yes or no, does the prosecution know which are the 30 witnesses it first intends to call? Does it know that? In other words, is it a decision that has been made, at least in broad terms, inside the prosecution that is being withheld from the defense for tactical reasons? Or is it that the prosecution does not yet know who it intends to call to open its case?
Thank you, Mr. Emerson. the answer to this after the break, unless Mr. Tully, very briefly then.
Very, very briefly, Your Honour, my apologies to our very hard-working interpreters. I just want to point out that in terms of the lack of the rule for this particular order, well, the reason that Article 13 exists is to add a human interpretation of a situation for good judgment. And this is the reason that I recontextualize my submissions to point out the delays that we face. There's an overwhelming delay. We face it now. We'll face it in the future. We continue to face it, and we continue to receive absolutely nothing from the prosecution to help us with our investigations. This is why I asked for your intervention, Your Honour. Thank you.
Thank you, Mr. Tully. Mr. Ellis.
Your Honour, very briefly, anyone listening to the prosecution's submissions could be forgiven for thinking that the prosecution is concerned that its witnesses are not going to come up to proof and is trying to get excuses in early, without evidence.
Thank you, Mr. Ellis. It is now 3:30. We will reconvene at 3:55. 3:55, 25-minute break.
All rise. All rise. Please be seated.
So let us now move to the defense investigations and next steps. I will give the floor to the parties separately on each item related to defense investigations, like we did for the past two status conferences, I believe. First, the status of the defense investigations. Second, on any potential request for unique investigative opportunities. Third, on any notice of an alibi or grounds for excluding responsibility. Fourth, on points of agreement on law and/or facts. Fifth, on objections to the admissibility of evidentiary material disclosed. And finally, whether and when the parties expect to be able to identify the list of issues subject to dispute and one with issues not subject to dispute, if any. I invite the parties to be concise on each item, and we will start with the general status of the defense investigations. In their submissions, the Vesely defense, the Selimi defense, and the Krasniki defense indicated that they do not foresee at this stage any difficulty in filing their respective pretrial brief on 21 October. The defense also indicate that their investigations are ongoing, but are hampered by a number of factors outside the control of the defense, notably the witness protocol and the redactions to the indictment. So I invite the parties to give an overview of their investigations, starting with Mr. Kihu, please.
Thank you, Your Honor. Would you prefer it if we just take it issue by issue, and then we'll just go around? Yes, Your Honor. Yes, obviously our investigation is continuing. Has it been hampered? Yes, and among other things, the witness protocol has significantly hampered us in the sense that we've had many witnesses that we have not been unable to speak with because obviously we respect the protocol. I know it's on appeal at this point, Judge, but we have abided by Your Honor's order, and we have, even though there have been contacts, I will tell you as an officer of the court, even I have contacts with some of those witnesses, those contacts have ceased once your order. That being said, that is a difficulty for us. What is another difficulty that I want to bring to Your Honor's attention, and we kind of glossed over it a little bit on the witnesses, and I know that Mr. Tully was talking about getting back to it sooner, is this new revelation on disclosures by the SPO. And in their submission, they noted that they have 68 witnesses where disclosure has been identified 30 days prior to trial, and 46,000 pages of material to be disclosed. Now, that is then broken down to 10,000 new pages. 25,000 pages from existing non-standard redactions will be lifted, and 11,000 pages when non-standard redactions are requested before the pretrial judge. That is an enormous amount of material to give to anyone 30 days before trial. We compound that with the fact that we don't know who's going to be testifying at the outset of this trial because the SPO has refused to let us know. So it's an enormous difficulty in that period of time to deal with 68 witnesses and then 46,000 pages. Now, 10,000 pages are new pages, but even the redacted pages, Your Honor, and I was going through this the past few days with my team and my client, many of those statements are virtually entirely redacted, such that you don't know names, you don't know dates, you don't know places, and you may have some obscure allegation in there, which is basically any information coming from witness statements of that nature is like getting a new witness statement. You're going to have to read it all from the beginning to decipher exactly what is going on here and where these people are fitting into the prosecution's case. That being said, Judge, of the 98 witnesses, of course, 68 23 additional are going to remain anonymous until 30 days before their testimony. And then we have 4 witnesses who are not going to be identified until 2 other witnesses are identified. One that is only going to be identified to the defendant and not to the accused, and 2 witnesses that we're never going to get the identities from. So, again, without looking at all of these issues parenthetically, but looking at it as a whole in preparation of this case, it is a very difficult proposition at this point to conduct this investigation with the protocol restrictions and these types of disclosures given to us at the 11th hour for us to decipher going to trial without any movement by the SPO on removing redactions or on who they're going to call for the first 3 months of trial. I know Your Honor has made those decisions before, and I don't intend to belabor the point, but Your Honor asked, how's the defense investigation going? That's how it's going. We are continuing to investigate, and we will continue to investigate. And I have some other issues concerning some of the witnesses. Is the defense entitled to be present there? And if the prosecution interviews that person, is it going to be videotaped with the registrar? How are we going to engage in this, and how are we going to solve this issue? Because it is an issue for us. And Your Honor, I wanted to bring it up to you because obviously I don't want to transgress and do anything that is counter to the order that you have. But I can tell you, and I can tell you in closed session who that witness is, and we can go from there. But there is a witness that's on their witness list that is going to be a defense witness. I have comments on the other issues that Your Honor set forth. I cede the floor to my colleagues, and I can go back with those other issues in a seriatim form at the appropriate point.
Thank you, Mr. Kihu. Mr. Emerson or Mr.
Mr. Strong will deal with the
Mr.
defense investigation.
Mr. Strong, please.
Thank you, Your Honor. Just to echo the comments, our investigation is also moving forward. We have raised challenges in prior status conferences, and they remain. Nonetheless, we're determined to meet the pretrial brief deadline and carry on as best we can. Just a note on the challenges that we're echoing from the Thaci team. What I hear are the extent of the redactions, and that's something that is also a challenge for us. The scope of this case is also something that we're wrestling with. I was informed this week by our case manager that we've crossed the ominous threshold of 1 million pages of disclosure has been served on the defense. And so we are in the process of understanding and processing that. But that is another challenge. That then coincides with what my colleague just mentioned. There's an additional 45,000 pages that are going to be made available 30 days before the trial. And we have the witness protocol to contend with. And so with those burdens on the defense, that's one of the reasons we've come to you and said and asked for the prosecution to make their case clear for the first set of witnesses. And again, we don't need to be dogmatic about it, but if we can get an understanding of generally where they're coming from to start the case, that allows us in this sea of information to have an anchor to advance our understanding of the case and advance our investigation in a meaningful way. So that's to reiterate that request. Just as a second note, we put into our submissions a request for clarification on Rule 201, and I'm happy to leave that for another part of the status conference. But I do want to circle back to that because we have a number of these requests ready to go. And I want to make sure that we raise this matter in a sensible way now rather than. Thank you.
I have a specific point on this request. Mr. Young, please.
In fact, Your Honour, before Mr. Tully addresses you on defence investigations, could I briefly come back to one short point which was raised before the break, which is on the defence request for notification of the first couple of months' evidence or witnesses. Would you hear me briefly on that?
You have 30 seconds.
Well, Your Honour, the point is simply this. Mr. Teager states that the trial will be held in the mechanisms of efficiency, but the prosecution say how and when the prosecution chooses to manage their witnesses is a matter for them. It's not, Your Honour. That's why you and the other judges are here. You're there, obviously, to manage the trial and to ensure a fair trial. How fair or efficient a trial is it in a case of this size and magnitude if the prosecution aren't even prepared to give us the first batch of witnesses that they intend to start with? Even, Your Honour, with respect to national jurisdictions on 3 to 4 5-day trials, it's very, very commonplace and good professional practice for the prosecution to disclose the first witnesses they call in the first week or 2 weeks of trial. Here we are in one of the largest cases in the world, and the prosecution are refusing to give us disclosure. It's simply not efficient, and it's totally unfair. And so I do implore Your Honour to recall and consider Article 39 of the rules, where you yourself, where you are requested to make an order to interfere here and make an order that we have this disclosure. It's what we're entitled to. We're entitled to know if they're starting with a particular crime scene or alleged zone, which crime scene, to give us some advance notice. It's only reasonable, it's fair. When you have so many witnesses, when you have 300-odd witnesses, to make us guess whether they're going to start with witness 280 or witness 1 to 5, it's just utterly unreasonable. Good case management dictates that Your Honour insists that they disclose to the defence for the purposes of efficiency who we start with. Otherwise, our rights are not being respected. We don't have the opportunity to focus our efforts, channel them where they should be channeled, because we have to be considering all the 300 when they know full well it's going to be witnesses 1 to 10. It's a reasonable request, and I ask you to make the order.
Thank you, Mr. Young. Mr. Tully, please.
Your Honour, very briefly, I've already touched on this topic in my submission, so I won't go back over it. Generally speaking, our submissions regarding this area of the agenda are not incredibly changed from last time. I can confirm, as you have in your summary, that we will be filing a pre-trial brief. I've realised we were slightly coy about it last time, but that was for good reason. We don't see any issues in filing in that time, with caveats that Mr. Roberts went over last time. But I do note, just for the sake of underlining, that the redactions is something that is, the delayed disclosure items and the non-standard redactions are something that concerns us greatly. Just to talk about the numbers, that's 10,000 new items, 36,000 documents that are affected by non-standard redactions, is that this is effectively the size of what would be a complex criminal trial in a domestic jurisdiction 30 days before trial. We reserve our position on that. It may be the case that we make applications for more time. We'll decide closer to the time, but just to give you a heads up on that and to give the prosecution a heads up on that too. I don't have anything else to add to that, except that we continue well with our investigations despite the obstacles we face, and we will continue to do so in the future, and we fully expect to meet that deadline that you have set for the pre-trial brief. Thank you, Your Honour.
Thank you, Mr. Tully. Mr. Ellis, please.
Your Honour, our positions on each of these agenda items are as set out in our written submissions. In relation to the pre-trial brief date, our investigation is ongoing. We are facing the same challenges as all other teams. But that said, we intend to file on the 21st of October. And of course, if anything changes on that, we will let the court know at the earliest opportunity. But we intend to file on that date. I did say before the break that I wanted to come back to this 1F on the agenda in relation to the delayed disclosure, and it's now been raised by others. I think I can state our position on it quite clearly for the record, Your Honour. If 46,000 pages are disclosed to the defence 30 days before trial, we cannot have a fair trial. That's my position on it. Just to try and explain that, no one can prepare that volume of material in 30 days. It would require us, if I were doing nothing else to read 1,500 pages every day of that 30-day period. And that's just to have read everything once. It's not to analyze, it's not to investigate, it's not to prepare opening speeches, it's not to prepare questions for witnesses. It is a wholly unacceptable, in my submission, amount of material to give to the defense at a late stage. I appreciate this is going to be met with the response that I'm relitigating issues that have previously been decided. But, Your Honour, what has happened in this case is that protective measures have been dealt with on a rolling basis. At no stage has anybody been told how many pages were left outstanding until 30 days before trial. So we learned for the first time this week that the total amount is going to be something like 46,000 pages. How can any team cope with that, Your Honour? And that is something I invite the court to take into account in any pending requests. And like my learned friend, Mr. Tully, we reserve all rights to make further applications if needed. But it should be clear to everybody, 46,000 pages cannot be a fair procedure.
Thank you, Mr. Ellis.
Before the prosecution mentions, Judge, I didn't say that.
Mr. Kihu.
Answer one of your questions about the pretrial brief. Of course, we are going to file a pretrial brief by the 21st of October. I neglected to say that. And with regard to what my learned friends were just talking about, the 68 witnesses and 46,000 pages, we would ask for leave. I know, Your Honor, gave that order 30 days before trial. There have been a lot of items that have been taken into account since that time. That order was made long before we had this, let's just say, something less than satisfactory disclosure. So we'd ask Your Honor to consider expanding that time to a period of at least 60 days.
Thank you, Mr. Kihu. Let us now move to request for unique investigative opportunities. In its written submissions, the Vesely defense indicated that it intends to request measures to preserve evidence under Rule 99. However, considering the need to carry out further preliminary investigations relating to such opportunities, ongoing litigation and on other matters, and the deadline for the filing of its pretrial brief, the defense is unable to commit to such filing requests by 28 October 2022. I note that the Selimi defense teams and the Krasniqi defense team do not currently intend to make any requests concerning unique investigative opportunities. I invite the Thaci defense team to indicate if they still intend to make any Rule 99 application and to give details on how many measures they will request. And in light of the preparation required for any unique investigative opportunity, and so as not to delay the transmission of the case to the trial panel, I invite the defense, or at least the defense team that intend to file a Rule 99 application, to indicate if it would be in a position to file a notice indicating their intent to file such request by 7 October 2022. Such notice would include the type of measures to be requested, the location where the measure is to be carried out, and the number of witnesses to be interviewed, if any. So only these information. These notices would be made without prejudice to any future determinations on the matter, and then requests pursuant to Rule 99 of the rules justifying the need for such measures would then be filed at a later stage, and I think 28 October is probably the last date that is still manageable in order for the case to be transferred for trial in a reasonable delay. Mr. Kihu, please.
Yes, Your Honor. We do intend to explore Rule 98 procedures. Obviously, this was 23 years ago. We stand here today at 3 witnesses at least who would have testified very positively for my client, Secretary Albright, Secretary of the United States, Ambassador Holbrooke, Senator Robert Dole. At least those 3 had all said very positive things about my client and would have testified had they had the opportunity. Of course, the 3 are now deceased. And what our proposal, Your Honor, is 9 elderly witnesses, elderly, just between the late 70s and frankly, the late 80s, and in various degrees of health. They're critical witnesses. They're international witnesses who were present on the ground. And what we advance to Your Honor is I certainly can give the list to Your Honor by the 7th of October, I believe you're delineating. Certainly I can meet that. What I wanted to come to the court today to discuss was the fashion under 99.3 that we should proceed, because the rule 99.3 says the depositions upon request of the parties are done with the participation of the pretrial judge or judge assigned by the president in a unique opportunity. So I submit to Your Honor that under these circumstances, for a variety of reasons, not the least of which is economy and time, is that we take these depositions and hopefully here in The Hague in this courtroom, checking with the witnesses depending on their health, but hopefully in The Hague here in the courtroom, before the trial panel, or at least if the president nominates one judge from the trial panel. We would have some efficiencies there in the sense that you would have obviously a taped interview, and the person would be seen by one of the trial judges, and of course, once down the line, the other judges could view it. But the other value of having one of the trial judges there while we do this deposition is their ability to examine that witness, ask questions, as the bench always does in proceedings such as this, in my experience. So in my submission, and we've become more formal about how it would go, it would seem to us that the most efficient way is to begin these depositions prior to the start of trial for these elderly people with a nomination of a judge by the president, hopefully one of the trial panel, so they can hear these critical witnesses. The trial chamber can participate with at least one witness, one judge, and it will save time down the line having to bring those people back and forth. But the critical issue here is we're now looking at a trial that is several years down the road. These are not witnesses except for one that is on the witness list of the prosecution, and it's something that the defense is going to have to put on. So I'm here, Your Honor, in large part seeking your guidance on that score and submitting to Your Honor that the procedure that I outlined for having the president nominate a judge so we can take these depositions might be the most efficient way to complete this task. I don't pretend to have a corner on the market or the answers in this regard, Judge, but that's what as I see it and as I go through it on the importance of taking these witnesses and having the participation of one member of the trial chamber at least, and as well as time and resources, it would appear, and I submit to Your Honor, that is the way we should go. But on the short answer, on the 7th of October, will we provide a list of people? I'm not sure if Your Honor wants that in a confidential form or an open filing. It can be either way as far as we're concerned. But we would ask that the court consider how we're going to proceed under these circumstances.
Thank you, Mr. Kihu. Can you make this filing before the 7th of October?
Well, yeah, I probably could, Judge, if I contact all these folks but my issue here, Judge, depending on the health of some of these individuals, I just have to check whether or not, for instance, they can fly here on their own accord, or this has to be done with some type of Zoom circumstances or Zoom equipment, et cetera. I haven't covered that particular track yet, but I will. But so if I could just have leave to the 7th on it, Judge, I would appreciate it. If I can do it before then, I certainly will. I will, as an officer of the court, I will try to do it as soon as I can. But given the fact that I need a little leeway here time-wise, I would ask for the 7th and try to do it before then.
Thank you, Mr. Kihu. Mr. Strong, please.
Yes, Your Honor, we have at most a very small amount of these opportunities that we're going to pursue. We can certainly meet the 7 October deadline. Our submissions were predicated on attempting to clear the deck in front of the pretrial brief, which has our attention at the moment. That that will certainly be seconded to our determination not to delay these proceedings and get to trial as soon as possible. So if the 7th of October is the date that will not delay proceedings, we will make sure to commit to that date. Thank you, Your Honor.
Thank you, Mr. Strong. I suppose the two other defense team don't have anything to add on this matter?
Just for the sake of getting the position down on the transcript, Your Honor, no, our position has been that we don't have any unique opportunity. We don't envisage any in our future, and that remains the case. So I can leave it to Mr. Krasniqi to confirm.
Thank you, Mr. Tully. And Mr. Ellis?
Yes, we don't currently intend to make any such application, Your Honor.
Thank you, Mr. Ellis. Just for clarification, both from Mr. Keogh and Mr. Strong, would you be in a position to make a Rule 99 request before the 7th? Because I think that from what you indicate, you already know who you would like to have interviewed. So I'm even wondering, could I set a deadline for the defense to file their Rule 99 application to the 7th October?
To file the application? That is going to be a little bit more difficult because we're going to need some time to go through things with some of these witnesses. We have some third-party countries that have their own concerns about this type of discussion. I'm sure Your Honor can understand that. Various countries want this entire matter, chapter and verse, I might add, to be run through their ministry and before they okay, number one, that it can be done, which I think we'll be able to do, but it's the scope of that the ministries are concerned with in this various countries. What exactly are we getting into in this regard? With regard to, and in that vein, one of the witnesses that is on the prosecution's witness list, one of the ministries is requesting the witness statement, and they participated in that witness statement being given to the prosecution, and they want a copy of the witness statement. And we told them, we are not in a position to give you a copy of the SPO's witness statement. Nevertheless, we would ask to do that for that witness that's on their list that is going to be one of our witnesses, but this is one of the hurdles of the protocol that we need to wend our way through.
Thank you, Mr. Keogh. Mr. Strong?
We'd also respectfully request that the 7th be the earliest date set. Thank you.
Thank you, Mr. Strong. Let us now move to the notice of an alibi and grounds for excluding responsibility. In its written submissions, the Vesely defense indicated that it currently intends to provide notice of alibi and is willing to commit to the deadline of 28 October 2022 to provide the relevant information pursuant to Rule 95. The Selimi defense also currently envisages potentially needing to give notice of an alibi or grounds for excluding responsibility. And the Krasniqi defense intends to address issues of alibi and any other grounds excluding responsibility within its pretrial brief, but it indicated that it is unlikely to be possible for the defense to provide a complete Rule 95.5 notice and any associated disclosure by 28 October 2022. All defense teams have also raised the issue of redactions in the indictment at the difficulty to file their notice. I invite the defense to indicate when they would be able to give notice of an alibi or grounds for excluding responsibility. And on the issue of redactions to the indictment, I invite the SPO to indicate whether they could provide a table that would indicate when each of the redactions in the indictment would be lifted pursuant to the current protective measures regime in place. Mr. Keogh, please.
Yes, Your Honor. We've addressed this issue in several prior pretrial conferences with Your Honor. And yes, are we going to assert an alibi defense? Because yes, my client during the, just take for instance a time frame between the end of Rambouillet conference in February through the spring, was in Europe meeting with international leaders in Oslo and Vienna and Paris, London, etc. So the problem we have is looking at the particular charges in the indictment. Many of them, and I can't count them all up, there are so many. the redactions are so extensive, we can't even tell when these events took place and where. So when we get these redactions lifted, or we can get a more complete piece of information that's going to give us time, place, and dates of things, we'll be able to file an alibi defense, but until that, we cannot.
Thank you, Mr. Kihu. Mr. Strong, please.
Yes, I don't have too much more to add to our written submissions. We believe we've identified at least two areas that may be possible, but we will have to adjust based on how the redactions unfold as they unfold. We would strongly support seeing a table to understand when redactions will be lifted and lifted across all instruments, the indictment, pretrial brief, as well as the witness's evidence. Thank you.
Thank you, Mr. Strong. Mr. Young, please.
Yes. I want to just reiterate the points made by Mr. Kehoe. Given the extensive redactions, it's difficult to say when we can disclose whether we will in fact serve a notice of alibi. It will depend upon what's in unredacted material that we're disclosed at some stage. And so that's why we use the word envisages potentially needing to give notice. We can't say we will because we don't know at this stage. Thank you.
Thank you, Mr. Young. Mr. Ellis, please.
Yes, with the material that we have, we'll do the best we can to address in our pre-trial brief. There are inevitably matters subject to redactions that can't be addressed by any defence team at this stage. And so we would also support a table from the prosecution indicating when those will be lifted.
Thank you, Mr. Ellis.
Mr. Your Honor, just Mr. Ellis reminded me of one thing concerning the pretrial brief. In our pretrial brief, we are going to have an extensive area of our clients' travels throughout Europe. Well, is that technically an alibi defense under the rule? I'm not sure. But nevertheless, it's going to give everybody an idea where our client was during many different time frames that are addressed during the course of this indictment. So I'm not trying to keep it too close to the vest, but I thought Your Honor should know that will be part of our trial brief.
Thank you, Mr. Kihu. Mr. Prosecutor, on the possibility to have a table, as I mentioned initially.
Your Honor, you'll appreciate this is a seat of the pants projection, but yes, I think it's possible, and we would endeavor to have it by the end of next month.
So by the end of October?
Yes.
Thank you, Mr. Prosecutor. Let us now move to points of agreement on law and/or facts. In its written submissions, the Vesely defense indicated that it rejected the two remaining proposed facts that were outstanding as of the last status conference, and it does not anticipate accepting further proposed agreed facts. The Selimi defense is still actively reviewing facts to determine whether or not it can agree to them, and notes the exchange of correspondence on certain facts between other teams which may facilitate agreement on some issues. And the Krasniqi defense has agreed to 8 facts in total. A notice summarizing these and any additional points of agreement could be prepared by 28 October 2022. The Vesely defense and the Krasniqi defense also indicated that they intend to submit a list of proposed agreed facts to the SPO and will endeavor to do so in sufficient time so that the resulting inter partes discussions could also be concluded by 28 October 2022. I invite the parties to give a timeline for their discussions on this matter and to confirm any agreement can be finalized by 28 October. Mr. Kihu, please.
Your Honor, we have agreed to 18 facts in total, and at this point, I mean, obviously we'll continue our discussion, but again, agreed facts depend on a fulsome understanding of the prosecution's case, which, needless to say, I don't mean to belabor the point, we don't have, not only with the redactions, but we're getting 68 witnesses 30 days before trial and another 46,000 pages of documents. Makes it very difficult. That type of disclosure or lack of disclosure makes it very difficult to us to agree on facts. That being said, we will continue to endeavor to do that. we are putting together some agreed facts concerning crimes by the Serb authorities, be it the Yugoslav army or the MUP or Serb paramilitaries, which engaged in many crimes, killing thousands of people during the operative time frame of this indictment. We will give those agreed facts to the prosecution for them to agree to. Whether or not that's completed by the 28th, I'm not sure. We'll endeavor to do so, but we should be able to give at least a preliminary idea of those Serb crimes for them, the prosecution to agree to relatively shortly.
Thank you, Mr. Kihu. Mr. Strong, please.
Yes, just to echo those comments, I think we're nearly there in terms of getting the agreed facts sorted between our defense teams. We hope by the end of this month to have something in a shape to send over to the prosecution, and we hope it's relatively not contentious in the sense that it's going to be mostly contextual, and much of it will be drawn from sources that have either been litigated at the ICTY or are pretty securely documented. Yeah, we hope that by the end of the month that can be handed over, and it will provide plenty of time for inter-party discussions, Your Honor. Thank you.
Thank you, Mr. Strong. Mr. Tully, please.
Your Honor, yes. Mr. Strong has spoken really for us. This is a defence-wide initiative. We're all working very hard on making sure that it is concise and sourced well enough that the prosecution can agree to it. The timelines given are accurate. We're in the same boat. That's it. Thank you, Your Honor.
Thank you, Mr. Tully. Mr. Ellis, please.
Nothing to add to that, Your Honor.
Thank you, Mr. Ellis. Mr. Prosecutor, do you want to add anything on this topic?
No, thank you, Your Honor.
Thank you, Mr. Prosecutor. Let us now move to objections to the admissibility of evidentiary material disclosed. In their written submissions, the defense teams indicate that they are not in a position to commit to a deadline for raising further objections to the admissibility of evidence. I invite the parties to indicate when they will be in a position to do so, even very briefly and not with very strong level of detail. Mr. Kihu.
Again, Judge, I'm sorry, Judge, I didn't know if it was on or not. Obviously, given where we are on the disclosure and the redactions and the charging document, having some agreement on evidentiary material and the admissibility of that material, we just can't make that at this point. We don't know what documents are going to try to be tendered across the bar, or through a witness, or through which witness this is going to be tendered. We don't have any idea about the provenance of many of these documents. As Your Honor knows, we have made 103 requests concerning documents coming from the Serb authorities, Serb governmental authorities, be the intelligence arm, be it their war crimes arm, or any other arm of the Serbian government, because of the doctoring and provenance, the doctoring and false documents coming from the Serb authorities that have been detailed in many other courts. It's important for us to understand the provenance of the documents that are being offered, i.e., where did you get them? Because if you got them from Serb authorities, they called in question on a variety of different levels. We haven't had that ability. And if last but not least, at this point, given our inability to interview many of the witnesses on the SPO's witness list because of the protocol, we've been unable to verify a variety of different documents which may have been signed by them. So at this point, I can't give you a date, and certainly not by the 28th of October, for a decision in that regard, or agreement, if you will.
Thank you, Mr. Kihu. Mr. Strong, please.
Yes, I have very little to add other than to join those comments. As I understand it, there are roughly 18,000 exhibits proposed by the prosecution at the moment. My understanding is that on that list there are duplicates, and the list is not in a final form. At a very minimum, we'd like to see those duplicates be addressed and understand where the exhibits are going to be substantiated, so how they're going to be tendered. Thank you, Your Honor.
Thank you, Mr. Strong. Mr. Tully, please.
Really nothing else to add, Your Honor. We join the comments, and we also echo the comment that we would need to know further as to what exactly the SPO is relying on at trial. It's certainly not those thousands of documents. It'll be far lower. The closer we get to that number, then we can maybe have a discussion then, but not right now.
Thank you, Mr. Tully. Mr. Ellis, please.
apologise. Your Honour, it's essentially the same position in that we're not able to deal with it right now. In relation to witness-related materials, the prosecution have indicated that they will be making Rule 153 or Rule 155 applications to the trial panel. It's at the point they make those applications that we'll see the material in support of that. There is very likely to be opposition to those, but we can't make the opposition first. We have to see the application. And it's a similar position in relation to other exhibits. We wait to see how the prosecution is actually going to adduce this material, whether it's through a witness or whether it's simply a bar table motion. These are, we would have thought, trial panel matters.
Thank you, Mr. Ellis. Let us now move to the list of issues subject to dispute and one with issues not subject to dispute. In its written submission, the Salimi defense indicated that it does not foresee creating a list of issues subject to dispute and those not subject to dispute beyond the agreed facts. The Krasniqi defense also indicated that the preparation of a separate list of issues in dispute and not in dispute, in addition to the notice of agreed facts discussed before, is unlikely to assist the trial panel in this case. I invite the parties to present briefly their views on this topic.
Your Honor, I think it's very unlikely that we'll be able to agree to such an item at this point, consistent with what my colleagues have said.
Thank you, Mr. Kihu. Mr. Strong, please.
We have nothing to add beyond our submissions, Your Honor. Thank you.
Thank you, Mr. Strong. Mr. Tully, please.
Nothing beyond the submissions, Your Honor. Thank you.
Thank you, Mr. Tully. Mr. Ellis, please.
Everything that we haven't agreed is disputed, Your Honour. And you've heard what we've agreed. It's very limited.
That makes it very clear. Thank you, Mr. Ellis. And finally, let's now move to the Vesely defense request of an appointment of a focal point for Kosovar institutions. In its written submissions, the Vesely defense raised the possibility of the appointment of a single representative within the Kosovo government to serve as focal point to expedite defense requests for assistance and information. I invite the defense to present its proposal, and I will also give the floor to the registry to indicate if it seems possible and appropriate. Mr. Strong.
Thank you, Your Honor. This request came out of where we are in our defense preparation. We have a number of Rule 102 requests ready to send to the relevant authorities in Kosovo, but before we did, we thought it was sensible to raise the matter here, both because of the volume of information in this trial is likely to result in a significantly higher number of requests that has the potential of overwhelming both the defense and judicial resources, and as well to try to be sensitive to transmitting confidential information. So those are the two reasons behind this request. We think that there'd be significant efficiency in creating a single focal point to capture all defense requests in this regard. And I think that's particularly the case as we move into trial and we're getting information that is going to form the basis of this request 30 days before the witness comes to testify. What we want to avoid is a situation where we're waiting on information from a relevant authority while a witness is in the box, and we either have to delay the trial or recall the witness when we get the information. So that's the position. I think that efficiency gives Your Honor the power to do it under Rule 95-2. I think we're in Your Honor's hands in terms of ultimately how this looks, but we would like some indication as soon as possible if you're inclined to move forward with this proposal or decline it, because we do need to get on with making these requests, even if it is on a case-by-case basis, as quickly as possible. Thank you.
Thank you, Mr. Strong. Any other defense team wants to add anything on this matter?
Yes, Your Honor,
Mr. Kihu?
if I can echo Mr. Strong's concerns. Our concern, well, our issue here, was when we have gone to the Kosovo authorities looking for files on criminal cases, they advised us that the entire hard copy file had been given to the SPO for a variety of files that we've asked for, and that they're in the custody of the SPO. With regard to those files taken from the Kosovo authorities, it may be best for the court to fashion a room here and for the SPO to take all the files that they got from the Kosovo authorities, put them in a room, and let us look at them. And if something needs to be copied, we can take it up from there. And of course, we can have somebody in the registrar seated there as we go through them to ensure that none of these documents are destroyed. It really doesn't make a difference to us. We just can't get to the documents or look at the documents anymore because they're gone. And it seemed to us it's a remedy that, based on in my career over the years when I've been doing this, that was a remedy that a court often fashioned by just taking these files, putting them in a room, and telling the parties, if you're looking at these dossiers, here they are, look at them, and we can take care of any copying, et cetera, from there. I offer that as a suggestion, as a possible suggestion to augment what my learned friend put before Your Honor, but we have to fashion this in some way. My concern is that any request made by us or Vasily, because we made the request, going back to the Kosovo authorities, is going to be quite simple. We don't have it anymore. The SPO does.
So this is an additional request to the request of the Vasily defense, in fact.
Judge, I'm just looking to find a way through. I mean, if Your Honor wants to nominate somebody to to navigate this fish weir, and so we get to where we want to be, if it means that person dealing with the authorities or that person putting those documents in an office here at the KSC for us to look, I don't think we much care the fashion in which it's done, as long as we have the ability to look at those documents.
Thank you, Mr. Kihu. Mr. Tully, please.
Yes, thank you, Your Honour. And we support in full the submissions of our colleagues from the team from Mr. Vasily, and hadn't considered up until now, but the alternatives suggested by Mr. Kehoe. If I can just offer with my support generally to the submissions, I do have some experience with a system similar to this. In the STL, I'm not sure if it was something known outside of the defence, but in the STL, the way the RFAs worked was that there was a focal point within the chambers. I'm sure you're well aware yourself, Your Honour. This helped quite a lot with confusion that we had at the start. We wrote hundreds, at least tens, possibly into the hundreds of RFAs that got lost in the meantime, simply because they came across the desk of a person who said, well, I don't have to deal with this. Even though it was a judge who was receiving it, this wasn't the way the system worked. So in our submission, it would help a lot if there was one person who it's now known to the rest of the officials, whoever they may be, that this person will be coming to them with the requests, that it's from the defence and that it's been approved by the court. Because a direct approach, especially from someone from the defence, can put officials in these institutions on high alert, fearing that there is some sort of improperness to the request, no matter how reasonable it is. So in our submission, we would find that the method proposed by counsel for Mr. Vasily is the most reasonable one, having seen it in action. It has its own problems, but we believe it is very reasonable in these circumstances. Thank you, Your Honour.
Thank you, Mr. Tully. Mr. Ellis, please.
We too support, Your Honour.
Thank you, Mr. Ellis. Mr. Nielsen, can you give us your thought on these proposals, please?
Thank you, Your Honour. So with regard to the request or the proposal by the defense for Mr. Vasily, you ask whether it's appropriate. We see no problem with it. In fact, we see great advantages with the system that is described. So that's the first thing. What we would like to add, though, is that the way we see it is that this is an internal matter for the Kosovo authorities and how they organize themselves in responding to requests from the parties. So we might not have much influence in that respect. We would still like to be helpful if it is of assistance. The registry would offer to reach out to the Kosovo authorities to see whether there is a possibility, if there is a willingness on the authorities' side to appoint someone. Thank you.
Thank you, Mr. Nielsen. Then I invite the registry to indeed reach out to the relevant authorities and to try to find a practicable solution, as you have just indicated. And we will try to set up a solution like that without any order at first. And then I invite you to report to me in case there is no solution that is found in the discussions you have with the Kosovo authorities.
Thank you, Your Honor. We will do so.
Thank you, Mr. Nielsen.
Yes,
Strong?
Your Honor, could I just invite some time framework to be added to this, because we are late in the day in terms of where we are in the trial process. We have these requests ready to go. This does not need to be a binding. This should be a suggestion rather than something that's binding, but so that we can follow up and say, you know, in 2 weeks' time, where are we? Thank you.
Thank you, Mr. Strong. I think this should be done as a matter of priority, Mr. Nielsen. So I invite you to start the discussions tomorrow or early next week at the latest, and try to get back to the defense within a 2 weeks time frame maximum. Do you think it's foreseeable, provided that you get the relevant and the pertinent information, of course?
From the registry side, there is no problem. I think within in the matter of days, we could reach out to the Kosovo authorities. Cannot say too much about when we'll get a response, but we'll push for a response as quickly as possible, of course.
Thank you, Mr. Nielsen. Mr. Kihu? Microphone, please.
Mr. Nielsen, in this regard, it may expedite matters that Mr. Strong has put forth. I think we can expect that the Kosovo authorities are going to say, we don't have it anymore. Mr. Nielsen, they're going to say it's with the SPO. That has been our the answer that we've received on several occasions concerning files. So if that's the case, and I'd be surprised were it not the case, what are our next steps from there, which is why I put on the table our viewing room, if you will, suggestion. But I do think that that's what they're going to tell you, at least at the outset. Maybe not for all these files, but for quite a few of them.
Mr. Nielsen, do you want to mention anything? Or Mr. Prosecutor, do you want to?
It just appeared to me that Mr. Kehoe was putting the cart slightly before the horse. I understand that Mr. Nielsen's task was going to be to inquire in response to Mr. Strong's request with regard to a focal point. Should that be successful, then other steps could presumably follow. But I think the point that Mr. Kehoe raised is slightly premature.
Mr. Kehoe?
There's no question I'm putting the cart before the horse. I don't think we agree on a point. I think there's peace in the world. But what I'm trying to is pass on to Mr. Nielsen the benefit of our experience in a fashion that he shouldn't be surprised if that's the case, so that we can expedite this concern and get these documents into place. So if in fact that is, and then the expectation level, at least 50-50, is going to be that that's what they're going to tell him, what's our next step? And do we have to wait another 2 weeks to get moving once that Mr. Nielsen gets that response? That's my only point. And if that is putting the cart before the horse, but I'm confident, based on our conversations with those folks, that that's going to be their position.
So we will first wait for the outcome of the discussions of the registry with the Kosovo authorities, and then, based on what these discussions will lead us to, we will assess the situation at that time. So let us now move to the last topic on our agenda, which is related to the representation of the victims in the case. In the scheduling order, I invited the Victims' Counsel to indicate whether he can already anticipate whether he wishes to present evidence, and if so, in relation to which issues, and further, whether any of the participating victims wish to present their views and concerns. My aim is to include the victims' representative views in the handover document. I invite the victims' counsels to make any general submissions on this issue if he wishes at this stage. Mr. Laws, please.
Well, thank you very much. And I can make some submissions which I hope will be helpful. The position as of today is that we certainly do intend to put material before the trial panel if we are permitted to do so. We think it's likely that we'll apply to call evidence under Rule 114.5 with the leave of the panel. And it's likely that that evidence will be oral, that it will be documentary, and quite possibly expert. This evidence would, of course, be focused on the impact of the crimes on the victims participating in the proceedings. We think it is likely that we will present some material by way of views and concerns, and we certainly think that it's possible there may be other areas of the case that we will want to address by way of evidence too. So I hope that's helpful. We'll certainly be calling material of one kind and another, going to perhaps more than one topic. But as Your Honour knows, there are 50 further victims recommended for admission to these proceedings by the Victims Participation Office, and there are, as we understand it, possibly more to come after that. So at the moment we don't know what evidence those further victims may offer or what issues may arise from their involvement or what views or concerns they may wish to share with the panel. So I hope the court will understand that at the moment we're only able to give limited assistance, but I hope that's at least of some help.
Thank you, Mr. Laws. This is very useful for me to put in the handover document. Let us move to the date of the next status. Mr. Hugh?
If I may, Judge, if Mr. Laws, does he have an idea of how many witnesses we're talking about at this point? An estimate?
Mr. Laws, do you want to reply to the question?
Well, as I said, we've got 50 pending applications and more to come, so it would be quite wrong for me to speculate at this stage.
Thank you, Mr. Laws. Let us now move to the date of the next status conference.
If I may, Judge, I had an issue to bring up to Your Honor's attention in the spirit of other topics.
I will give you the floor in due course.
Sure. You tell
unless
me.
it's about the victims' submissions.
No, Your Honor, it's about some other procedural matters.
Then, in a couple of minutes, let us move to the date of the next status conference. In the scheduling order, I suggested Tuesday, 18 October, as the potential date for the next status conference. However, two defense teams indicated their preference for a date after the filing of their pretrial brief. So I invite the parties to indicate what week would suit them best for the next status conference. Mr. Prosecutor.
I think we've previously indicated consistently that we're available at the court's convenience. It's the same.
Thank you, Mr. Prosecutor. Mr. Kihu?
And, Your Honor, consistent with, I believe, information transmitted to your chambers, the week of the 24th, just the following week after we finish filing our pretrial brief, would be fine with us.
Thank you, Mr. Kihu. Mr. Emerson, please.
Likewise, immediately or as soon as convenient after the filing of the pretrial brief, if that's acceptable to Your Honour.
Thank you, Mr. Emerson. Mr. Young, please.
Your Honour, again, the week of the 24th would be ideal, ideally on the 25th or a date later that week. Thank you.
Thank you, Mr. Young. Mr. Ellis, please.
Yes, the same position, Your Honour, that week.
Thank you, Mr. Ellis. Mr. Laws, please.
Yes, we'll certainly be available that week, Your Honour. Thank you.
Thank you, Mr. Laws. You will receive a scaling order that will include the agenda before the status conference, but I will make sure to inform you of the date via CMU in the following days. At this point, I would like to ask the parties and participants whether they have any other issues they would like to raise. Mr. Prosecutor.
No, Your Honor. Thank you very much.
Thank you, Mr. Prosecutor. Mr. Kihu?
Yes, Your Honor, I have two issues. The first issue with regard to witnesses, I would ask the SPO to view some of the public statements by some of the witnesses. I'm not sure if these are the protected witnesses or not, but there have been some people giving statements in the public. If they happen to be protected witnesses, there should be some concern, or their protective measures should be removed.
This can be done inter partes with the SPO, I believe.
Yes, Your Honor.
Thank you, Mr. Tully. Mr. Ellis, please.
Nothing further. Thank you, Your Honor.
Thank you, Mr. Ellis. Mr. Laws, please.
Nothing to add, thank you, Your Honor.
Thank you, Mr. Laws. So we will now break for 20 minutes, and I will come back after the break with a couple of oral orders on the matters we discussed today. The hearing is adjourned.
All rise. All rise. Please be seated.
Before we conclude today's hearing, I will issue my first oral order related to unique investigative opportunities. In light of the parties' submissions, I order the defense to file a notice of any investigative opportunities by 7 October 2022, including any information necessary for their preparation, should a request be granted, such as the type of measures requested, location where the measure is to be carried out, the number of witnesses to be interviewed, if any, and the recommended procedure for carrying out the measure. Request justifying the need for such measures shall be filed by 28 October 2022. This concludes my first oral order. I will now issue my second oral order concerning notices of alibi. In light of the parties' submissions, I order the defense to file notices of alibi or grounds for excluding responsibility to the extent possible, pursuant to Rule 95(5) of the rules, by 28 October 2022. This concludes my second oral order. I will now issue my third oral order concerning points of agreement on law and/or facts. In light of the parties' submissions, I order, pursuant to Rule 95(3) of the rules, the parties to file notices indicating where points of agreement on issues of law and/or facts have been reached in relation to their respective proposals by 18 November 2022. This concludes my third oral order. I will now issue my fourth oral order concerning objections to the admissibility of evidentiary material. I order, pursuant to Rule 95(2)(e) of the rules, the defense to provide, by 18 November 2022, any objections regarding the admissibility of evidentiary material disclosed to the extent possible. This concludes my fourth oral order. I will now issue my fifth oral order concerning redactions in the indictment. I order the SPO to file, by 28 October 2022, a notice on the record of when each redaction in the indictment is scheduled to be lifted according to the current protective measures regime. This concludes my fifth oral order. And I will now issue my sixth oral order. I order the SPO to file a provisional list of the first 40 witnesses it intends to call at trial by 18 November 2022. This concludes my sixth oral order. This concludes today's hearing. As usual, I thank the parties and participants for their attendance, the audiovisual technicians, the interpreters, security personnel for their assistance, and the hearing is adjourned.
All rise.